Court officer. My lord, I filed a matter of contempt. I'm for a homeowners association, my lord. The judge bench ordered the deputy commissioner to file a report. It's been 2 years since they've not filed the report, my lord.
2 years.
Yes, my lord. Kindly have the matter listed, my lord.
Contempt.
Yes, my lord.
September.
Obliged, my lord.
Fresh matter. Petitioner, the appellant had supplied 602 metric tons of the green fodder to the government. Half of the amount they have paid. The other half of the amount, they have not paid the amount. We have filed a writ petition. On filing writ petition, they have paid half of the amount. Now remaining half of the amount they have to pay. Not the learned single judge, not the dismissed the writ petition only on the ground of the disputed fact. Not it is not disputed fact. Not
Let you argue when it is possible. You want to post- What is the urgency?
Not urgency is not, he brought the loan and not the supplied the not
You are
the
paid half of the amount.
correct not, but he had took the
Let it-
loan and not.
All
the
right, let
supplied.
it come on somewhere in 18 September.
Will may please your lordship.
Yes, this side will continue. Yes,
Serial number 57. After 4 weeks, my lord.
57 after 4 weeks.
For complete compliance of the office subjection.
That is writ appeal after 4 weeks. Why?
For some,
It is 22 appeal, therefore.
for a complete compliance of the office subjection, I need 4 weeks, my lord.
18 September. 18 September,
18 September.
57, 57.
57, my lord.
So stand out to 18 September, within which time all the office objections shall be removed.
Lord, one matter which we had argued, Lord, Pollution Control Board matter.
I am aware of.
November 14th is the, it is
Your
expired.
term ends in November.
Yes,
I know that. We know that.
Therefore, Lord, I request, please.
The serial number 16. It can be kindly posted on Monday. Serial is not being issued.
Serial number
C,
3.
writ appeal.
I oppose for any adjournment, my lords.
3 is not
Responding.
readable. 3.
Monday,
Which?
serial number 16, 16.
Once.
My lords, it is not on the original jurisdiction, my lords. It is on the supervisory jurisdiction, my lords. On the order of the magistrate, they approached the High Court. A single bench has passed the petition or dismissed the petition, my lord. On that, my lords, now I can come down before this court. The petition is not maintained, my lords. In fact, placing this, my lord, the dragging the matter before magistrate, the sales certificate issued 10 years back, my lords. 10 years back, the sales certificate issued, my lords, seeking one other petition. They have filed 20 petitions, my lords. All bogus petitions came to be withdrawn, dismissed, my lords. Even recently, the single bench of this court, my lord, dismissed the petition on that count. Again, on that, they have filed this writ appeal. Placing this, my lord, they moved before magistrate, saying that the writ appeal is pending before magistrate, the High Court. Therefore, matter shall be considered, my lords. I humble submission that may not be adjourned, my lords, may it be passed, my lords. Let it be called in the serial, my lords. I'll enlighten this court, my lords. What is the conduct of the petitioner here, my lords?
Let it be heard only on Monday. Monday it should be.
Let it be called out. Let us.
Serial number 19, my lord, please.
Serial number-
Tax matter.
serial number-
Writ number 688 of 2000.
Serial number?
Serial number 19.
19. Yes. 622. Yes. What do you want?
Tax matter along with writ appeal number 688 of 2024.
To be listed with writ appeal number 688 of 2224 as requested by learned advocate for appellant. Yes.
For posting.
Yes.
For posting. Not with
Yes,
the-
one by one. Yes.
Number 12, my lord. Number 12.
What do you want?
And the delay. 2 weeks delay.
12 2 weeks. 19 September.
Kindly pray for next week. Matter. Next week for matter. Memo for posting.
It will come once it is.
My lord, the impugn order dated 15/4, my lord. The day onwards, the calculation of interest is calculated, so I kindly.
What is the urgency?
Urgency is, my lord, on 15th impugn order is been made, my lord.
You
That day
remove.
itself,
Remove the office objection will be posted
Office objection has been complaints
when they are removed.
24/7, 2024.
Well, then list it 20th September.
May I please, Your Lordship, a memo for posting, Lord, a PIL was filed in 21. I appear for the respondents, about 50 respondents, my Lord, bona fide agriculturists who are owners of lands. My Lord, the dispute concerns certain encroachments, alleged encroachments in about 18 survey numbers. It so happened that, my Lord, one of the survey numbers that's included also is with respect to the owners who have been granted land way back, about 70 years ago. Now, my lord, the difficulty is that because of this pending PIL, my lord, now these agriculturists, they are not able to get their lands 4D done. Because the revenue authorities have given an endorsement saying that because this PIL is pending, we can't do anything.
And the interim order is passed.
No interim order, my lord.
Then there is no.
Because I filed an early hearing application on, in January. At least the early hearing application can be taken
You
up.
filed an application,
Yes, my lord, an early hearing application was filed.
18 September.
My lord, serial number 36, my lord. If this matter could be heard at 2:30, my lord, because each time the matter, this is the doctrine of pleasure, a similar matter where the same notification was challenged, your lordship was pleased to pass the order on 7th of August. This is a similar matter, my lord, it's at serial number 36. If in the event it doesn't reach by the afternoon, my lord, if 2:30 it could be heard, my lord.
The urgency is there.
Please, my lord, the urgency is that the chairperson has been continuing in the post by virtue of the interim order granted in favor of the chairperson, that is the appellant. Therefore, my lord, though the term has come to an end, he has continued to carry on in view of the interim order, my lord.
Tomorrow,
My lord, it's listed today.
you take up tomorrow at 2:30
Tomorrow.
or day after tomorrow, whenever.
No, there is an urgency, my lord, and since your lordship had already looked into this issue, it's a similar issue,
If the
wherein the statute
Language
specifically,
of the provision is same,
the provision over here,
judgment will govern your case.
no, over here, though it is a similar notification, the issue over here is the doctrine of pleasure is incorporated into the statute itself. And this is a different statute. The lordship had decided on the Rajiv Gandhi University Act.
All right, but today it is listed,
Please, my lord.
like 2:30, unless it
2:30.
reaches earlier.
Please, my lord.
Unless it reaches earlier, 2:30.
Please, please, please. Much obliged.
My lord, with your lordship's kind leave,
Yes, madam.
my lord, serial number 30, I appear for the petitioner in the matter, my lords.
30, 30.
30, please, my lords.
Yes.
My lords, may I request for it after 2 weeks, my lords, I have some inconvenience today.
Oh, when
The
shall-
respondents are the state, my lord.
13th, 13 September,
Very well, very well.
13 September,
I'm grateful, my lords.
Serial number 13, serial number 13.
13.
Wait for week. Wait for week time, my lord. Not instant.
Praying for weeks' time. 13th of September.
Number 44. But we have engaged the senior counsel, but there's some inconvenience with the date. Kindly to, like, another date would be given.
But it is 21 appeal, writ petition. It was submitted by learned advocate Ms. So and said that the senior counsel who is to conduct this petition has personal difficulty. Send out which date?
For that.
Any date? Next. Twenty-third September.
My lord. 2 weeks time it is added. The complaint officer.
Yes,
Serial number 48, your lord.
48.
The government advocate was supposed to file a memo. We have not received the copy. Copy is not served on us.
Copy is received today. So you on time.
Yes, sir.
Forty-eight.
Serial number 48.
48.
Yes, sir.
657.
Yes,
Rate of it. When do you want? 11th, 12th of September.
Obliged.
My lord, posting.
Serial number 67, my lord.
Urgency for interim order. Is this 47 group?
Serial number 67.
67.
Weeks time will be granted to comply the office of.
Why?
Because what has happened is in the writ petition, they have filed a few documents.
24 September. Yes.
Posting for me. Urgency for injunction. Interim order. The writ petition passed by my favor. Writ petition passed by my favor, but not executed. Panchayat. Petition for ನಮ್ಮ ಕಡೆ ಆಗಿದೆ ಸರ್. ಅದನ್ನ ಎಂಟ್ರಿ ಮಾಡ್ರು ಇದು ಮಾಡದೇನೆ ಅವರು ಖಾತೆನೂ ಮಾಡ್ಕೊಡದೆ ಇದು ಮಾಡಿದ್ರೆ.
What is saying? Saying.
Entry order.
So you file approval proceeding. You file proceeding, get it listed. Serial number? Serial number? 80. 19. Is already adjourned. 19 is not adjourned. It is adjourned. Interim order granted earlier shall continue to operate till the next.
Your Honor, serial number 54. I have addressed the office objections. I have given a copy to the respondent, and I have actually filed the entire copy of the writ petition with the Honorable Court on 9/7, Your Honor. So I would request I be granted the interim prayer orders today.
Let it reach, say 24, you can't mention 54. Let it reach in seriatim.
Okay.
Once it reaches hearing, we'll consider on merits.
Yeah, for presenting the legal summary of the writ appeal,
When it
I
is
would
called
need
out, you do.
under 30 minutes to present the legal summary of all the facts that is known to the Honorable Court.
Whatever you want to do, when it is called out, you do, not now.
Okay.
When it reaches, you do it, whatever you want to do.
Okay.
My lord, serial number 72.
Serial number
72, my lord. 2 days time may be given.
72.
72.
Yes.
2 days time may be given, my lord. Everything is ready. 2 days time may be given, my lord. We'll comply the office obligation.
So 3 weeks time is granted to comply with your observation. In all
Much
matters, 3 weeks grant, uniformly granted. 4 weeks is granted, where it is for 5th and 6th time. And 6 weeks where it is first time. Yeah, hit my hand.
List 2, serial number 1. Mallikarjun R.
My lords, I am for the petition, the matter, my lords. My lord, this petition, my lords, had moved for a requisition to the central government to consider my application to enhance the post-graduation seats from 2 to 6, my lords. I am an institution by name K. Dental College, my lords. I run both graduation and post-graduation, my lords. In fact, my lords, I had given permission to run 2 post-graduation seats. And my lords, it's a rule as per the regulation that whenever we need enhancement of seats, my lords, we can make an application to the central government. In fact, my lords, in this case, my lords, the application date starts from 15th of March every year and ends on 7th of April, my lords. In fact, my lords, I moved an application from Bangalore on 27th of March, my lords, and it has reached the central government on 9th of April, my lords, as against 7th of April. And my lord, they did not consider my application to enhance the seats of post-graduation from 2 to 6. In fact, my lord, they sent a reply saying that since your application did not reach well in time and there was delay of 2 days, we cannot consider application, my lords. In fact, my lords, I move this honorable court, my lords, and this court was pleased to pass an order, my lords, where an interim direction was given to the central government to consider the application within 4 weeks, my lords. My lords, till such period, my lords, my application is not being considered, my lords, in spite of an order passed by this honorable court, my lords. In fact, my lords, by considering this application, my lords, there is no loss or prejudice that is going to be caused to the central government, my lords, because, my lords, the admissions would generally commences, my lords, in the month of May next year, my lords. My lords, if my take my lords to page number 49, my lords, page number 49, my lords, of my petition, my lords. If not, my lords would appreciate that the application shall be made.
Who appears? Some order was passed on 23/5/20.
Central government. बाकी अनुपमा हेगडे,
Union of India. who
देशपांडे.
There is no urgency.
My lords, may I take my lords to page number 49, my lords? Page number 49, my lords. My lord, this is what the schedule, my lords. My lord, the first column refers to, my lord, the application should be made between 15th of March to 7th of April, my lords. My lord, from then, my lord, the central government is supposed to move this application to the Dental Council of India by 30th April, my lords. My lords, and from then on, before 15th October, my lords, the Dental Council of India shall make recommendation to central government, my lords. My lords, in spite of the direction passed by this court, my lords, my application is not considered till date, my lords. My lords, which by any chance, if this date crosses, my lords, then thereafter, my lords, shall be put into prejudice, my lords,
Which date?
by 15th of October, my lords. Because, my lords, this application ought to have been forwarded within 13th of April, my lords, 30th of April. My lords, in the month of August, my lords. Of course, my lords, I admit, my lords, I consider there's a delay of 2 days in reaching the application, my lords. My lords, but I sent the application on 23rd of March itself, my lords. From Bangalore to Delhi, in the usual course, it would take 3 to 4 days, my lords. But however, my lords, since it was Saturday and Sunday, my lords, the application reached on 9th of April, my lords. In fact, my lords, the notification says, the regulation says the central government can modify, my lords. My lords, may I take to that the below column, my lords, on the same page number 49, my lords, at clause 2, my lords, at note number 2. 49 at note number 2, my lords, on the same page, my lords. The time schedule indicated above may be modified by the central government for the reasons to be recorded in writing in respect of any class or category of application, my lords. My lords, since I moved the petition before this honorable court and this court has given a direction to the central government to consider my application, my lords, I fall under the last category of these words, my lords. I fall under the category of this class and my application shall fall under this, my lords. When there's a direction passed by this honorable court, my lords, it is a duty of the central government that ought to have been considered my application, my lords. My lords, in spite of that, my lords, my application is not being considered, my lords.
Let the council come.
Please, my lords. Pass on, my lords.
Still number 2. The Saravanas.
Lots 2 to 4. Apparently, there are some objections which I need to comply. Lots may accommodate till Monday, my lords. My lords, the serial number 63 is also pertaining to the very same matter in list 1. Lots serial number 63, 2, 3, and 4. Lots may request the matter may be taken up in the second list on Monday, my lords. The same thing, my lords. Your lordships have considered this matter.
You have to file this condonation application.
Lords, I'll get it filed. Lords, I've already sent it for filing. Lords, the reason why I'm submitting is your lordships have already passed an order. Lords, relating to the seat matrix, your lordships have stated, but the differential fees amount has to be deposited. Here there is a different same matter, my lords. It's by virtue of the orders which was taken up. The matters were heard together, my lords, by the learned single judge, but separate orders were passed in the different writ petitions. It's verbatim the same orders. So Monday, my lords.
Monday is what date? 27th.
Lordships. 27 Tuesday. Yes, my lords. Great.
10 to 27th, within which time the council for the
Along with serial number 60.
appellant shall remove the office objection,
Please.
including that the delay condonation application wherever necessary shall be filed.
Along with serial number 63, my lords. It's
To
also.
be listed with serial number 63. Your number I have.
The list one. Still number one. The Kaveri Timaya.
I pay for the complainant, my lords, I filed an application seeking rectification of the order. Para 6, I had filed this contempt petition because the respondent mother had not complied with an order passed in a writ petition directing her to hand over the custody of the child to the father, complainant father, my lord. During the course of the proceedings, I'd also submitted that she's a habitual defaulter. In para 6, my lord, should have been the respondent instead of the complainant, my lord.
It was pointed out by learned advocate Ms. So-and-so for the complainant to the note for being spoken to that in order dated
25/7/24.
5/7/24 passed in PCC number 507/24, more particularly in paragraph 6, the word into the complainant has been wrongly transcribed. It ought to have been respondent. The word should have been into the respondent. Therefore, it is directed that in paragraph 6 of the aforesaid order, the word complainant in all comma shall be substituted by the word respondent. Full stop, the in all comma. The order shall be corrected accordingly and shall be reissued.
Much obliged.
Rest contempt matters. Still number two. Siddharth R.
What is there? Let it go to 9th September.
Still number three. Anand Ram K.
Appear for the complainant. The operative portion is at page 27, my lords. A mandamus is issued to restore, my lord, the name of the petitioner
One humble submission.
in respect of
Before
fault
I can-
house.
The state has preferred a writ appeal, Vella. It is listed as the FR number 1116 of 2024. There are some office objections. We will comply with the office objection once the matter will be listed. 2 weeks time may be granted. We've already filed the writ appeal.
Additional government advocate stated that the writ appeal is filed by the government against the order brought under the contempt jurisdiction. He pressed time for 2 weeks. And further state said within 2 weeks, necessary order shall be obtained in the writ appeal. Appropriate order shall be obtained by from the competent court in the writ appeal. Full stop. 4 weeks time is granted within which the
Lord, this matter may
appellant
be,
state shall
can be connected with the writ appeal, my lord.
get the,
Number has not been given.
Okay.
you want to connect it, all right.
Can be
Number
connected.
is there,
No, number is not there because only the filing register is there.
filed.
Filing register number is there.
We are on the contrary saying that within 4 weeks, unless they obtain an appropriate order, this will be complied.
Yes,
4 weeks time is granted to, and it is observed that unless within such time, the writ appeal is posted, is got posted before the competent court and appropriate orders are obtained, the respondents shall be liable to comply with the directions of law in a single judge. Stand over to 30th September.
public.
December 4. To Nagaraj S. J.
Paying for complaint. Lord, there is violation of interim order passed by the land single judge, my lord, annexure A, my lord. Page 18. My lord, in the said writ petition, my lord, we have challenged the order passed by the deputy commissioner, wherein he directed the subordinate to evict me from The land, my lord, is measuring about 34 guntas, and the complaint is in occupation of the said land for more than 70 years, my lord. There is also a dwelling house and cattle shed and other things, my lord. The order passed by the incompetent authority that is challenged, my lord, the land single judge was pleased to grant interim order, my lord, staying the order passed by the deputy commissioner, my lord, page 21, my lord. Last but one paragraph, my lord. Consequently, there shall be an ad interim order of stay of the impugned order passed by the deputy commissioner at annexure AA till the next date of hearing. My lord.
It is the
When
order dated, sorry, it is the order dated 12/3/24, passed by a single judge in the proceedings of writ petition number 7381 of 24, which is brought under the contempt jurisdiction. Full stop. It is admitted in an interim order whereby ad interim leave is granted by a single judge, staying the order passed by the deputy till the next date of hearing. Full stop. Three aspects emerge from the order, from the nature of the order. Full stop. Firstly, it is an ad interim order where the other side is yet to be heard. Secondly, it is passed till the next date of hearing. Full stop. Thirdly, the merits of the main controversy are pending at large for consideration before a single judge. At this stage, rights of the parties are not crystallized or finalized in the aforesaid circumstances paragraph. The court is not inclined to invoke the, exercise the jurisdiction and the contempt of Courts Act 1971, leaving it open for the complainant to approach the court where the petitions, where the proceedings of the writ petition are pending, to work out his right and remedies. The court does not express any opinion.
Lordship, here by submission that, my lord,
The contempt proceeding is disposed of in the aforesaid terms. Next.
Number 5, Venugopal. I appear for complainant in this.
Yes.
Thoughts, the operative portion is at page number 19 in page.
No rights are crystallized लिखा है, इसके बाद एक sentence add करो. There are not wrappings of finality in the order. Not wrappings, TRLP. Yes, what is it?
The operating portion is at page number 19, my lords.
It is also interim order.
And also I have communicated to
What is
accused
the
number
order?
1 and 2.
Dispose of the petition.
Yes,
Okay.
yes. 4 weeks time was granted. Despite that, there is no action taken by the accused number 1 and 2.
So trees are to be cut.
Yes, yes, ma'am.
Why?
Because for the agricultural development, it comes in between. So that has to be removed.
Eucalyptus
Yeah, eucalyptus and acacias.
and acacia trees. What is acacia tree?
It's one of the trees, which is not, yeah, firewood, probably I can say it as fire.
Notice written 23rd September.
Number 6, Ravindra Gajana.
Please, my lords. Herein the petitioner was granted applied for the grant of a quarry lease, my lords, over an area of 5 acres. And this is the third round of litigation.
Notice written number 23rd September.
Respondent number 1 and 2 maybe is asked to appear before my lords because this is the third round of litigation, my lords.
Let us,
Please,
let it be earlier, keep it earlier,
please.
20th September.
Green bench matters, still number 7.
My lord,
MS.
my lord, I appear for the petitioner in this matter.
Hmm.
My lord, the petitioner has sought for writ of mandamus. My lord, wide annexure E, my lord, and representation came to be filed to the respondent number 1 and 2, my lord, to take action against the respondent number 3, where, my lord, that company, which is adjacent to the poultry farm run by the petitioner, has causing pollution. The respondent number 3 is a Kirloskar Ferrous Industries Limited. My lord, due to the pollution caused by that company, my lord, the birds in our poultry farm has been affected. My lord, The petitioner has started the poultry farm in the year 1990, my lord. Thereafter, my lord, after a few years, my lord, the company, the respondent number 3 has started the company. My lord, our request is that, my lord, to control the pollution. My lord, no action has been taken on the representation given by the petitioner. Hence, my lord, we have come.
Who will appear? You will be, some representation is made. You consider and decide.
They've sought for 15 days, my lord.
Heard learned advocate Mr. So and so with the petitioner. Whereas learned advocate Mr. Mahesh Chaudhary appears upon service of copy of the petition in advance on behalf of the respondent pollution control board, to assist the court. The only prayer made in this petition filed under Article 226 of the Constitution is to direct respondent number 1 and 2, who are the Chairman Karnataka State Pollution Control Board and the Environment Officer of the Pollution Control Board, to consider the representation dated 7/7/23 filed by the petitioner. Also, the said representation figures on record at Annexure E, figures on record in duplicate Annexure E, page 27, page 77, page 27. The representation is with regard to the investigating and taking suitable action against pollutants impacting poultry farming activities. The petitioner happens to be a company. Which has got the franchise from Venkateshwara Hatcheries, HATCHERIES Limited, Pune, for purpose of breeding birds. At the site. According to the petitioner, whom I stated in the representation, permitting the poultry farming will have polluting will have the consequences injurious to the livestock of approximately 80,000 layer birds, which is being nurtured by the petitioner. It is also the case that immediate steps are required to be taken against the impact of toxic pollutants emitted by a company located in the area. It is stated that the bird mortality has increased. It is the case that the authorities are required to take appropriate steps under the law to curb such activities and the effect thereof. Full stop. It will be in the fitness of things paragraph that the respondent number 1 and 2 through its competent authority examines the grievance of the petitioner made through, raised through the aforementioned representation dated 7th July 2023, which is already made before the respondent 1 and 2. This petition is therefore directed. This petition is therefore disposed of by directing the competent authority of the respondent number 1 and 2 to decide the said representation, to consider and decide the said representation in accordance with law and on its own merits, preferably within a period of 6 weeks from now. This court has not gone into, nor has expressed any opinion on the merits of.
That's just one submission. Let the counsel for the petitioner submit a copy of the petition minutes.
Full stop.
I will submit.
That we will have a
Within,
record of.
6 weeks, and the copy of the petition shall also be submitted to the respondent authorities along with the, to be part of the representation.
Please.
The petition is disposed of.
Great.
Still number 8.
Here for the petition.
What is it?
Blood endorsement annexure A challenge. The bid process has been put to halt without assigning any reasons for it. Blood annexure D, they invited the tender for grant of mining lease on 18/3/2023. Blood.
So the auction is put on hold in November 23.
Please, man.
So we are almost 1 year is there.
1 year.
10 months.
10 months. Blood.
So what is your right?
Blood, I may not have a right, blood. It's ultimately, blood, under the auction rules, I am entitled to consider my application for grant of mining lease. I participated in the e-bid. Blood, I have submitted the tender, paying 5 lakh rupees fee for the application. Blood, I have given 2,09,73,000 rupees of bank guarantee as a bid security for the purpose of participating in the e-auction. No decision has been taken, Milad, under Rule 9, Milad, of the mineral auction rules. Once the bid process is started, Milad, it must either result in grant of mining lease or for cancellation, annulment as required under Rule 9 of the mineral auction rules 2015. Why this bid has been withheld is not forthcoming from the respondents. Milad.
The case of the petitioner, as submitted by learned advocate Mr. So-and-so, for the petitioner, is entirely that the auction process for mining lease, which was started by the authorities, have been put on hold since 18/11/23, and no further action are taken. It is the case of the petitioner that it has uploaded all the technical and financial bid for grant of mining in respect of the property in question. However, because of the inaction on part of the respondents in not proceeding further, the petitioner is not aware about the status of his application. Full stop. It is also the case that the respondents have been acting for extraneous and irrelevant considerations. Notice returnable on 18th September.
All are government, may I take it to the government and
Learned additional advocate, Mrs.
Please. Great.
Accepts notice on behalf of. Yes, next.
Bill number 9.
So this was for orders.
Great. Yes. Very good. Writ petition is allowed. Respondent number 1 is directed to issue CFO in favor of the petitioner within 3 weeks from the date of service of this order. Great.
This is number 10.
My lords, I represent in first matter, syllable 10. The syllable 10 and 10.1 are interlinked together. 10 and 10.1. My lords, the short question is this. I filed a public interest litigation on the ground that the municipality has proceeded to construct the building without securing the permission from Archaeological department. On the ground that the subject matter of land falls within the restricted and prohibited area contemplated in the Archaeological Act. To put it in other words, the municipality without taking permission from the Archaeological department, since the land falls within the on the restricted area, prohibited area, they should take permission from the Archaeological department to proceed with the construction. Without doing so, the proceeding with the construction is bad in law, which is contrary to the statute, is my limited grievance in serial number 10 in the public interest litigation filed by me. Insofar as serial number 10.1, the municipality has filed a writ petition challenging the rejection of their permission by the Archaeological department. My lords, 10.2 is a municipality filed a writ petition challenging the permission declined by the Archaeological department to construct the building. So in any event, if a 10.2 writ petition is allowed, my PL will become infructuous. This is all how the 10.10 and 10.2 is interlinked together. Well, let's.
I sought permission. Permission is rejected against which petition is filed. And this order will court also permitted.
This is the commercial complex.
No, it's a municipality.
Vegetable.
Little market.
My lords, one development I should bring to my lord's notice. I filed a memo to withdraw the writ petition. That my party is not interested with a signature. I filed a memo that to withdraw the writ petition, PA. Court has declined to accept my memo on the ground that we treat the said PL as a suo motu and appointed me as a amicus curiae in the said PA. That's how the order is passed in my writ petition is concerned.
10.1, my lord, the award of the contract by way of tender is under challenge because there is no proper tender. Without any proper tender, as it is 10.1.
Where we ended last, on last occasion.
My lord, I have filed my report, my lord, pursuant to lordship's directions. The construction is not in the restricted area. It is at a distance of 192 meters, which is the regulated area. And I have gone on record and said that it does not affect the monument. The only issue is the construction was commenced without seeking prior permission. Now, my lord, if your lordship's permit, we will consider and grant the NOC now. Lord, that is the simple solution for this.
Observation. So what kind of reading you have lastly filed?
It's there.
Some affidavit is filed? By you.
Lord, I have filed a report, my lord, pursuant to
Where
lordship.
is that report last?
My lord, I filed it along with the memo.
Dated 8/8.
Date. Yes, sir. 8/8 of August.
Twentieth nine. Once. 29/7. Where is that?
8/8/2020.
Part of this report.
May I just pass on.
ನಾನು ಮತ್ತೆ ಮೆಮೊ ಇಲ್ಲಿ
Connected matter, it is filed, my lord, 10.
Lordship may find it in 10.2, not in 10.2 file could decide. In this report, page 1, my lord, last paragraph, my lord, beginning with words in compliance. In compliance with the said order, this respondent on June 2021 have filed an assessment report.
There is no direct impact, that is what.
There is no direct impact. There is no direct.
Only difficulty is that they have put up the construction, half of the way we issued the strict notice. So they have, to, without considering that, they have to confirm, the order has to be made specific to that.
Lord, the only aberration is that we had said not to construct, huh? We had said not to construct.
They had said we repeat it. This should not be treated as a precedent for the.
They made it. Correct. Same thing I am.
Lord, one submission that I'd like to make is, Lord, in the interest of finding a solution, Lord, today I will concede that I'm willing to consider granting a NOC, even though it has been commenced, not pursuant to your Lordship's directions. But fact of the matter is that earlier we had issued a show cause notice, called them not to proceed with the construction, but yet they proceeded with the construction. It should not be treated as a precedent. I mean, in this case, not we are willing to concede, not in the interest of justice, so that the people of that city are not deprived of a market.
For this kind of before this, of course, the concession by the ASI, my lord, I'm the only contesting party now, point one. The first matter, my lords, they have filed a memo now, not withdrawing, etc., though filed in PI. In the point one, where is the contesting party, my lord. My lord, as far as the archaeological law is concerned, there is a total ban. Now, this only court also took serious note that there was no permission granted, my lord, and as the construction was going on, this honorable court restrained the construction. And then the construction went on, and initially this honorable court, any honorable court laid down, my lord, any construction would be subject to the further orders. Despite this, some construction went on. The two aspects, my lord, one is the whether any concession can be granted by the concerned authority, my lords, for construction. And in the letter they say, if the honorable court is granting any orders permitting it, we have no objection. That is the tenor of the statement filed, and we are not. What they say is that it not be treated as a precedent. Let it flow from the honorable court. My respectful submission is, as far as the law is concerned, my lord, there cannot be any concession by them, and my lord, no permission can be granted, and permission must be granted by the authorities before construction. And if they proceed with the construction, my lord, that's an offence. I beg to draw my lord's kind attention to how the Honorable Supreme Court recently has analyzed it, my lord. I have submitted the two rulings on the memo, my lord. I may say quota.
My lords, probably his case is calling for tender is called in question. In the
Whatever,
rectification.
my lord, it's like this. Now one of the person petitioner who has filed the PAL, he wished to withdraw it, that is the case. And what circumstances it is filed to withdraw, and therefore the honorable court refused to grant permission for withdrawal is another aspect. Now I am entitled to assist the honorable court and submit as far as the position of law at what the Supreme Court has said, my lords. I cannot be stopped by the other co-petitioner because who is colluding with the concerned contractor.
My lord, sorry, my lord. This is
That's the truth, my lord.
Given by-
Decision number one.
Given by whom?
ನಮ್ದು ರೆಡಿ ಇಟ್ಟಿರೋಣ
Argued by the-
ನಮ್ಗೇನೋ copy ಕೊಟ್ಟಿದ್ರಾ?
ಇಲ್ಲ ಸರ್
ನಾವು party ಇಲ್ಲ. I am not a party there, ನನಗೆ ಕೊಟ್ಟಿಲ್ಲ.
Now, my lord, the Archaeological Survey of India, 2012. I beg to take the honorable court directly to the synopsis which we have filed, my lords. In the garb of innovation, the owner of a building cannot demolish the existing structure and raise a new one, and the competent authority cannot grant permission for such reconstruction. That the question was whether can it be reconstructed. Need to implement the policy enshrined in Article 49 of the Constitution
ನೋಟ್ಸ್
and 1958 Act, that is to preserve and protect ancient and historical monuments and archaeological sites and remains of national importance. In the name of development and accommodating the need for multi-story structures, High Court could not issue the mandamus to central government to review or reconsider the notification.
ಸೈಟೇಷನ್ ಅದು ಕೊಟ್ಟಿದೆ
And that too by ignoring that large number of protected monuments have been facing the threat of extinction. If effective steps are not taken to check the same, these monuments may become part of the history. That was then 2020 edition. I beg to take the honorable court to page number 23, my lord, of the list. Para 27, my lords. Even when license is granted in violation of the law, the Honorable Supreme Court directed for demolition. That was a decision from this honorable court, my lords, regarding the Humpy Act, which is akin to the Ancient and Protected Monuments Act, my lords. Similar provision, without permission, can it be constructed? Now, coming to the provisions of the act as such, my lords. Act is clear. 200 meters, there cannot be any construction. And one is the regulated area and the protected area. No construction without permission. Now, I beg to directly take the honorable court to the various orders passed by this honorable court at the initial stage. I beg to take the honorable court to the order dated 19/3/21 passed by this honorable court, wherein the order dated 16th July 2019 records a prima facie finding that the seventh respondent, the town municipal council, has admitted the construction in the regulated area of a protected monument, place called Chautra Aramane at Mudbidri, without obtaining permission under subsection 2 of section 2C of the Ancient Monuments and Archaeological Sites and Remains Act. This petition is filed as a PAL for protection of monuments, and so we cannot allow the petition to be withdrawn. Therefore, it will be treated as suo motu writ petition. Next, para 4 is invited the document placed on record by the advocate for seventh respondent along with the memo and affidavit. With a letter dated so and so addressed by the Government of India, Ministry of Culture, National Monuments Authority to the competent authority of ASI, rejecting the application made by the seventh respondent. One aspect is this, the continuous orders passed, and therefore this honorable court holds is against section 20C. My lord, section 20C is a total ban. Neither the ASI nor the courts have any power to lift the ban, my lord, unless this honorable court exception circumstances are shown. Your lordship may kindly see the present case, conduct of the contractor. He constructs. Municipality allows it to construct without permission. And this honorable court directly prohibits it. Initial order is any construction is subject to the result. Now, what is being constructed? Up to first floor, the construction is being done. And there is a prohibition order after noting all these points. Now, my lords, there is also direction by the honorable court why there is no prosecution. Act provides for the prosecution. The statutory bodies are bound to obey the law, and especially law for preserving the environment and archaeological sites. Now, this admittedly within 200 meters. Within 200 meters, there cannot be any construction. Now, my lord, the conduct of the contractor permits any discretionary from this honorable court. My submission is no. And coupled with this, the continuous orders passed and whereby show cause notice have been issued, my lords, why action has not been taken? Prosecution has not been initiated. At this stage, also kindly see point 1. Point 1 is how he got the contract. Now, my lord, any contract of the public land, a valuable public land, my lord, can be given by following the proper procedure. Any procedure has been followed. The first point, according to me, is the file in point 1, my lord, whether the award of the contract is proper. My lord, as the law prevailing as on that date, value of the construction is more than 2 crores. 60 days, mandatory notice, public notice under the transparency of public procurements, my lord. No such notice. Kindly see the file of point 1, my lords, whether the grant of land in this manner, allotment of the work is proper. This honorable court had called for the entire file, my lords. Now, to satisfy whether this prime land is about 1 acre in the city was granted properly. Kindly see the relevant date. Date of notice, annexure B, public notice in the newspaper is 23/12/2016. And last date for tender is 20th January 2017. As per Rule 17, as it stood then, my lord, mandatory is 60 days. This 23rd December to 20th January. This called for by the municipality. No tender by any person. Up to 20th January. Has it been extended by inviting one more notification? No. What they say is, my lords, this tender has been submitted on 13th February. Last date, January 20th. 13th February 2017, one tender is submitted. And how this date comes? This date comes, they say, one authority called, my lords, the trust fund. Trust pool fund, my lord, is authority. That letter, they have themselves now enclosed along with the
All of you can take seat.
Please, my lord, please.
my lord,
Please.
this on, as per this on report's direction, my lord, the concerned executive officer of the town panchayat filed an affidavit dated 23. I was trying to insist upon on report, the process is illegal. Process of the tender itself is illegal, not authorized by and approved by any law. One submission is, my lords, 20th was the last date without giving 60 days is illegal. Second, the tender received on 13th February 2017, when there was no such date prescribed in the public notice at all. How this is permitted? For that, the answer given by the municipal chief officer and also the statement of objections is that one authority called Karnataka Water and Sanitation Pooled Fund has extended the time by an internal communication. May I humbly pray the honorable court to permit me to bring to the kind notice of this honorable court that document which is marked as annexure R1 in the statement of respond number 2.
Relating to tender process.
My lords, once the tender process goes out, is held to be illegal. That contractor has no right to continue. My lord, contractor will have the right to go on with the work, subject to other factors, my lords. If the honorable court, for any reason, finds out that there is an exception circumstance.
We'll consider day after tomorrow. It is virtually argued.
Yes.
My point, my lord, only 2 sentences, my lords permits, that Karnataka Water and Sanitation Pooled Fund by way of a document, internal communication says, I am extending it. Pooled fund is no authority to extend the time. It's not by way of public notice. And this is the only person along with his own another entity, they file an application, they file the tender and tender is granted. And the pooled fund authority says, I am extending it by an internal communication to the municipality. I am extending it. Pooled fund authority, it's no legal entity, has no legal entity. There's no business. It's not a superior authority to the municipality. And it says I'm extending it. Not only extending it, it says initially we fixed 1.25 crores as the EMD amount. Now we feel it's wrong. We therefore reduce it.
No,
As my
Lord,
lord
Lord, on the, I have nothing to say on the tender. But in respect of the submission that my learned friend made on the provisions of the act, I have got a very quick response to it. Lord, my learned friend's contention was that for a distance of 200 meters, there is a complete ban. Lord, he is not right. Lord, let me demonstrate. If your lordships kindly has a look at the provisions of the Ancient Monuments Act, Lord, section 20A, I'll just take 2 minutes, Lord. Section 20A of the Ancient Monuments Act. my lord, 20A to 20Q were inserted by the Amendment Act of 2010. 20A, my lord, declares what is a prohibited area. And my lord, that defines it as 100 meters from the protected monument. And then my lordship would now kindly have a look at 20B, which declares the regulated area, which is from 101 to 200 meters. So from 101 meters to 200 meters is the regulated area. Now, what can be done in the regulated area is found in 20C. My learned friend made a statement that under 20C, there is a complete prohibition. But please have a look at subsection 2, which I'd like to read for my lordship's consideration. Subsection 2 of section 20C of the Ancient Monuments Act. My lord, beginning with the words any person. Subsection 2 of 20 capital C. Any person who owns or possesses any building or structure or land in any regulated area and desires to carry out any construction or reconstruction or repair or renovation of such building or structure on such land as the case may be, may make an application to the competent authority for carrying out construction or reconstruction or repair or renovation as the case may be. So construction is permitted in the regulated area, but with prior permission. And that prior permission is to be taken under Rule 34. Therefore, my lord, my learned friend is not right in submitting that there is a complete ban.
Definitions also. Prohibited area and regulated area under section 2HA and H2L, my lord, is defined separately. So there are two distinct areas.
My lord, there are also judgments of the Supreme Court which says permission need not be prior permission. Post facto permission also could be granted. That is the judgments of Supreme Court. I will bring it to the notice of the court because statute does not use the word prior permission. It says permission. The rejection of the application of the municipality is only on the ground that prior permission is not taken. Statute does not use the word prior permission. It says permission. Therefore, the rejection by the NMA of an application is bad. I will bring it to the notice of the court to Supreme Court judgments directly on the point. That's my question.
No, on that, my lord, I would not agree with my learned friend because the words used is every person intending to undertake any construction shall at least 3 months before the date of commencement of construction. So I would still, my lord, my stand is that prior permission is required. But my lord, if your lordships pleases, my lord, if a case is made out, your lordships will condone that delay. And my lord, your lordships condone that delay, I will consider the application.
My lord, if it is to be condoned, I have nothing more to say because I would be the beneficiary of it.
My only submission was, my lord, without permission, there cannot be any construction, therefore prohibition. With permission, of course, with the permission is granted.
Lord, can it be Tuesday, my lord? Friday, there is some difficulty. Tuesday, my lord, Tuesday? Friday, I am not here, my lord. So Tuesday, my lord. Next Tuesday. I am grateful.
Oblige me.
Great, okay.
Next level. Okay. Then it's questions are closed.
Let them.
Close again. We have called off all operations. You have done 2 reports, sir. 3 reports.
In this matter, my lord.
All on record. Yeah? These are on record.
Number 11.
we have submitted our report, my lords, with regard to the landslide, my lords, where 11 people were missing, out of which 8 bodies were found, 3 are still missing, my lords. In fact, your lordships had asked the other side to reply to our status report, my lords. They are supposed to answer.
My lords, I appear on behalf of the petitioner. I am on VC, my lords. May I submit, my lords? Am I audible?
Yes, Mr.
Maybe you have nothing further to say.
My lords, as per the information which we have got, we had filed the petition at a stage when the bodies were not recovered. And we had hoped that we would be able to retrieve the persons who were involved in this accident. Now that stage has gone by. Now we have been informed that subsequent to this, my lords had even ordered that the rescue or whatever operations should not be stopped. We are told that there is a gentleman who belongs to the locality called Ishwar Malpe, who was involved in the activity of diving and retrieving the bodies on earlier occasion also. He was also present in the site, but now the state government is refusing his assistance to bring out the body, nor is the state government taking measures to retrieve the body at least. Now, those who were this gentleman, we have been informed that Ishwar Malpe has been threatened by with police action if he gets retrieval of body.
Out
The
of
family
total-
only asking for retrieval of body so that it can at least carry out the last rites, my lords.
Last rights.
We are out of 11, my lords, we are not able to, 3 are still missing, my lords. The number of people deployed by us to find these 3 people is, my lords, SDRF, 42 people we are deployed, my lords. NDRF, my lords, is 31 people, 60 army people, 12 navy people, 26 fire people, 2 from the Coast Guard, totally 171 people. My learned friend is complaining about 1 individual, my lords. From army, navy, Coast Guard, NDRF, SDRF, my lords, all 171 people we have engaged. Your lordship, may kindly see this sketch for a moment, my lord.
My lords, I am not on an adversarial litigation, my lord.
Therefore, my lords,
I'm not complaining that this was not done.
Lordship,
I completely understand these activities were carried out. These activities were carried out, and now at present, after your lordship's order,
Your lordship, may kindly turn the next page for a moment, my lords. Next page, my lords. Your lordships will get that white portion of property is the landslide area, my lords. Next to that is the road, next to is the river, my lords. That is where the landslide took place, my lords. The river, my lords, if you go, lordship, go back, joins the sea, my lords, in a distance of 8.9 kilometers, my lords. So therefore, my lords, and this river, my lords, is nearly, I'm given to understand, nearly 100 kilometers, my lords.
Have you filed some counter to the?
No, my lords. Yes, not. No, they are not filed.
Then you file, Mr. Whatever you want to say, place on record so that we can appreciate.
please, I'll place it on record. I'm
Lord,
only
with effect from August, my lord, the water currents have increased. They are in excess of 7 knots. We can't deploy our diving team. My lord, diving team did their job for more than a week.
And more than 1 month. Nearly.
And they have recorded this. No, no, we can't risk the lives of the diving team. It is in excess of 7 knots, my lord, it is dangerous.
Therefore, my lords, what is humanly possible, my lords, and it, in fact, I feel, my lord, they have gone all the way, my lord, appointing 171 people to recover, find out for this 171 personnel, my lords, to identify these 3 bodies, my lords, or the missing person. I don't want to say the missing people, my lords. So therefore, my lords, whatever is possible, we'll do. So therefore, continuing this public interest in that sense may not arise, my lords.
Yes, what do you say?
My lords, I'll place my reply on affidavit. That's a separate thing. And I'm very clear on my case that I am not on an adversarial litigation. I do not doubt any of these. But as on date, they have stopped the operation. That's what I could understand, my lords. No activities have been taken place subsequent to placing of the record, and after your lordship passed a direction that the search may not be stopped.
No, it is dangerous for the people who are going to do the rescue also, my lords. We can't.
Now I have been told,
Today when the
as per the
petition came up-
information which I have
Now
received.
listen, please
Yes,
listen.
yes, my
Today
lords,
when the
please.
petition came up for consideration, learned Advocate General Superannuation Secretary as well as learned Additional Surveyor General Mr. Kamath both submitted that the rescue operations are still continued.
As of now, we have
as
stopped.
of now,
No, as on today, we have stopped because, my lord, the water level is quite dangerous for them to.
171 employees.
They've been employed till last week, my lord.
Though the
Till 16th of August.
Though in the last week, the operations have to be suspended in view of the water,
Due to excessive water current.
the excessive water.
Current.
Current. In excess of 7 knots, my lord. KNOTS, 7 knots.
Current is measured in
The water currents are measured in knots. So if it is beyond 7 knots, my lord, we can't deploy any rescue operations.
My memo dated 5/8. Teams of SDRF, state,
NDRF, SDRF, NDRF, Army, Navy,
SDRF, NDRF, Army, Navy.
Fire.
Coast Guard.
Coast Guard, please.
Coast Guard. Were active. Rescue operations. You read the water current in 7 knots, KNOTS. Were active in rescue operations to continue their efforts to trace out the 3 missing bodies. Full stop. Affidavit was filed in the last occasion. Full stop. Today, learned advocate for the petitioner submitted that yet to file reply to the said affidavit and that he wants to file such reply. Full stop. The court
We can't supplement our
finds
expenses.
that the best of the efforts have been put up by the authorities in the rescue operations, and only because of the aforesaid impediment, the operations are temporarily suspended. Full stop. If the petitioner wants to file further pleadings, an opportunity is given till the next date, stand over to 18th September.
Please be. In fact, if your lordship see the sketch, my lord, it's.
You are also doing some rehabilitation work.
Rehabilitation as of now, nothing, my lord, because we have given compensation to all the deceased, my lord. We have given.
So it is also part of rehabilitation.
Please, that, in fact, I have also placed, my lord, I'll place that on the next date, my lord.
So there-
Insofar as what is the state government done for the rehabilitation, I'll place.
The respondent shall also place details with regard to the steps taken towards rehabilitation of the affected
Please, we'll do that.
inhabitants of the area.
Please.
Oblige, my lords.
So 11 and 12 are urgent. 12 and 13 are urgent. Number 14, Mr. Anant Kumar C.
This case, I appear for the appellant, my lords.
Here for the statement.
This case I appear for the appellant, my lords. Challenge the order passed by the learned single judge at Annexure A in page number 16. Setting aside the order passed by the respondent number 1 on the ground that there is a suit pending before the court, my lords. Now the respondents had challenged the revenue entries standing in the name of the appellant herein before the second respondent on the ground that there is a registered partition deed way back in the year 1969. That document is produced at Annexure H, my lords. In page number 54. There is a typed copy of that version is there. This registered document of partition deed was kept in dark from 1969 till 2023, my lords. In 2023, the respondent initiates an action before the respondent number 2, challenging the entries standing in my name to be mutated in their name. That application came to be allowed by the respondent number 2 and permitted the respondent's name to be reflected in the revenue entries. I challenged that entries before the deputy commissioner, who is the respondent number 1 before this court. And the respondent number 1 has set aside the order, rightly set aside the order, my lords. It is that order which was challenged before the learned single judge. Now, during the pendency of this proceedings, my lords, I had already initiated a suit seeking a declaratory relief against the respondent herein, challenging the very same order, my lords, very same document before the trial court, seeking null and void against the same respondents, my lord. Now, along with this writ appeal, my lords, I have also filed 2 applications. One is for stay and the other one is for production of documents. My lords may kindly peruse the document number 6 in the application which I have filed. May kindly be looked into, my lords, which will establish the conduct of the respondents. Along with document number 8, my lords. With the application, my lords. That is at in page number 172 and 173. Now, basically, my lords, this is a suit, this is the property which my father had purchased by way of a sale deed, which I have produced in the additional documents. Subsequent to the death of my father, the property was transferred in the name of my mother, which remained till 2023. And after that, the revenue entries were changed in the name of the respondents by virtue of the order passed by the assistant commissioner, who is the respondent number 2, my lords. It was that order which was challenged before the first respondent. Now, my lords may kindly peruse in page number 171, 172 and 173, my lords, in the additional documents IA which I had filed. In the year 1969, that is on 38/1969 itself, my lords, there is an order at in page number 172. May I please, my lords? In page number 172, in the order portion, my lords. Peruse the records and heard the parties. Respondent number 2, Chandrana, states in his statement that no consent of the appellant is my mother, my lords, has been obtained at the time of change of kata to his name, and the kata of the lands in question may be made in the name of the appellant as prayed for by her. Appellant says that while changing the kata of the land, doubtful records have been built upon the fraudulent signatures of the appellants. This is the opinion given by the respondent number 2 himself way back in the year 1969, my lords.
Where is the order dated 29/3/20?
My lords.
Where is the order dated 29/3/20?
Lord, annexed J, page 120.
120.
Order of the Deputy Commissioner Revenue.
Order of the Deputy Commissioner, my lords. It is at in page number 130. 120, my lords. That's a translated copy. The final order is at 135, in page number 135, my lords. As it is confirmed that
Registered sale deed is in whose favor?
in my father's name, my lords, which I have produced it along with the application filed by me. I have produced the sale deed copy, my lords. That stands in the name of my father.
Mutation entry was made.
Mutation entry was made after the
Your
death
favor.
of my father in my mother's name. From 1969 till 2010 to 23, it was not disturbed, my lords.
Based on that registered deed.
Exactly, my lords. After the death of my father, the name of my mother was mutated in the name of the revenue entries.
So what,
Subsequent to the death of my mother, the respondents approached the respondent number 2. 4 to 10 approached respondent number 2 in the guise of this partition deed and got their names mutated. It was that order which I had challenged before the respondent number 1, my
then
lords.
what is the suit filed by you?
I filed a suit for declaratory relief claiming that I am the absolute owner and the alleged partition deed, which is on the strength of which they have got it transferred, is to be null and void and not binding on me.
So how
That
can
suit is pending for consideration, my lords.
registered deed in their favor? And the petition is allowed.
Yes, my lords. Before the respondent number 1, the petition is allowed. That order was challenged before the learned single judge, but the learned single judge has come to the conclusion that since the
Entry-
suit is pending,
Entry stands in your favor.
right now it is not, my lords, by virtue of the order passed by the learned single judge. They have got it mutated in their names again, my lords. The only reasoning that the learned single judge finds is since there is a suit, it has to be adjudicated there. But this is a very document which I had challenged in the suit also, my lords. At in page number 172 of the documents, additional documents which I have produced itself shows the conduct. Way back in the year 1969 itself, they had forged the signature of my mother and got the documents transferred in their name. Subsequently, he himself undertakes before the assistant commissioner, that is a respondent number 2, stating that there is a fraudulent transactions that have happened and the signatures have been forged, and based on that, my mother's name was again restored in the year 1969, my lords. That document I have produced at in page number 172, 173. The order is very clear on that, my lords. That order is not challenged by the respondents till date. Had that partition deed been registered, they would have got that transferred way back in the year 69 itself, my lords. That partition deed was kept in dark from 1969 till 2023, after till the death of my mother. It is only after that they had challenged it before the
By
assistant.
judgment and order dated 21st June 24. Learned single judge allowed the writ petition of the petitioners, respondents herein, to set aside the order stated 29/3/24 passed by respondent 2, as well as the conferring order passed by respondent 1 dated 9/2/24. By the said orders, mutation entry, which stood in the name of the present appellants, was maintained. Full stop. The mutation entry was registered, was made on the basis of the registered sale deed, executed in favor of the father of the petition, father of the
Yes, my lords.
appellants.
Yes.
Full stop.
1949 is the sale deed.
Very good. It was on the basis of some partition deed by way of internal settlement entered into between the parties that the petitioners approached the revenue authorities to get the mutation altered, while the authorities did not pass any orders in favor of the petitioners, alone a single judge set aside the orders and permitted the mutation in the name of the petitioners on the basis of the. It is a registered partition deed.
It is a registered partition deed.
Then
Had it been registered from 1969, no attempt has been made by them to change the revenue entries. And added to that, my lords, 38/1969 is the order of undertaking made by one of the respondent himself, which I have produced before this honorable court.
registered partition deeds, registered partition deed. Full stop. The parties are family members. वो बीच में आता है ना, internal arrangement, वो निकाल दें. Take out that two words. The parties are family members who entered into the partition, registered partition deed, which is a registered partition deed.
And I'm not a party to that partition deed also, my lords.
You are not part.
I'm not a party to that partition deed. It is merely created by the respondents themselves. It is that document, my lords, it is,
Lord,
that
it's
is the
an
reason why I had challenged it before the civil
Effect
court,
of
my
the case
lords.
notice to the respondents, returnable on.
They have already filed a caveat, my lords. I've already served the copies to them.
Then let him come. Let them come. Will be disposed of finally.
A date may be fixed, my lords.
Ultimately, this mutation will stand subject to the outcome of your suit. If they come, we'll say that and dispose of them.
A date may be fixed, my lords, today.
Monday, 27th.
28th or 29th.
28th.
Much obliged.
You are not telling that somebody is filed. Yes, next.
Number 15, the Sagar V. Shastri.
Please, your lordship, I represent the appellants. The very same order passed by the learned single judge has been challenged by respondent number 2 herein in writ appeal number 199 of
Writ appeal number 199 of 24.
of 2024. Man.
Listed together, which is a cross appeal on 30th September,
It is posted on 29th. My lord.
29th.
Lord, I may kindly be permitted, we may kindly be permitted to take out notice to the respondents therein. Will furnish the council.
Date is posted.
29th. Man. It is posted.
All right, notice written around 29.
Notice on the council's. My lord.
To be listed with writ appeal number 199 of 24, which is stated to be a cross appeal.
Notice on the respective councils we will take. Man. Because they have already
In addition to the normal mode of service, council is permitted to show copy of the writ appeal to the councils appearing in the original procedure.
Number 16, Mr. D.P. Mahesh.
For the appellant. That's one short accommodation.
But the respondent in the matter is anonymous.
Senior is Landslide. Can we kindly
Short
post it?
accommodation.
My lords, this is the matter which I opposed in the morning, my lords.
Yes.
My lords, he had almost filed 14 petitions which came to be dismissed on merits. There is one more attempt made by the petitioner herein.
That's one
Petitioner
short.
appeal.
Yes, my lords. My lords, on basis on this, my lords, though the sales certificate was issued in the year 2021 till date, my lords, I am unable to get the possession, my lords. My lord, the facts of the case in nutshell is this, my lords. The borrower has borrowed the money from the bank in the year 2014, my lords. Within 3 months, he became non-performing assets, my lords. Thereafter, he did not pay anything, my lords. And he moved to DRT, my lords. In the meantime, we have issued for 13-4, my lords. In the year 2016-4, my lords, the 13-4 was allowed, my lords. And thereafter, he challenged before this SA, my lords, where order was passed. He did not make good the interim order, my lords, that came to be dismissed. Again, he challenged that order to the Sessions Court, my lords. He dragged the matter for 2 long years. That came to be dismissed. He approached the High Court, my lords, a single judge, my lords, allowed the petition, given interim order, my lords, did not comply the order, my lord. That came to be dismissed. My lords, after all litigation for 10 long years, he kept this litigation pot boiling. And now he moves one application, my lord, before the magistrate, where section 14 applications came to be allowed. My lords, as a bank, my lords, have the power under section 14 to move to the magistrate, my lords. Magistrate allowed the application saying that you are entitled to take the possession, my lords. My lords, after this allowed, he moves an application saying that I am the purchaser under the sales certificate. So therefore, implead this, the person who has purchased the property under the sales certificate, my lords. My lord, the observation of the single judge is very clear, my lords, that once an application filed before the magistrate under section 14 is allowed, the magistrate becomes functus officio. he does not have any power to try the matter or to consider the application, my lords. My lords, the observation of the single judge, my lords, is at page number 10, my lords. May I take my lords to page number 10, my lords? This is an order passed upon my petition wherein I have challenged the order passed by the magistrate allowing the application filed by a borrower, where borrower says my property is sold under auction to XYZ. So include that XYZ in this 14 proceedings. My lords, how does in a 14 proceedings that a borrower could be brought in? And moreover, my lords, it is an admitted fact that there is already a sale certificate issued in the year 2021. He has not challenged the sale certificate, my lords. My lords, all the remedy he had got was only to appear before the DRT, my lords, and not before the High Court at all, my lords. My lords, may I take my lords to the observation made by this single judge at page number 12, my lords. Petition page number 12. Para number 4, my lords. A perusal on material on record, including the impugned order, will indicate that the sole ground on which the impediment application filed by the respondent has been allowed by the trial court is by holding that there were proceedings between respondents and the petitioner bank in WP number so and so. And since there was a possibility of auction, the auction purchaser deserves to be imputed as respondent number 2. In this context, it is relevant to state that the aforesaid writ petition has been disposed of wide final order dated so and so. In addition to the same, it was always open for the respondent to settle the dispute amicably with the petitioner, having regard to the scope and ambit of proceedings under 14 of the SARFAESI Act, which had already attained finality. The question of impleading the auction purchaser at the instance of respondent would not arise, particularly when the trial court has become functus officio upon passing the order under section 14 of SARFAESI Act. My lords, once the magistrate has become functus officio, my lords, he does not have any power to consider to accept the application, my lords. My lords, may I take my lords to this, the application, my lords. The application, my lords, is at page number, my lords.
Why do you want time?
Lord, senior is unwell, my lords. Just a short accommodation, my lords. Just a short accommodation. My lords,
28.
please. My lord, section 4 does not permit, my lords. My lords, it's a order passed on a supervisory jurisdiction.
Take time on the ground of counsel.
My humble submission is that, my lords, he appeared before magistrate and he says that the matter is pending before writ appeal court. Therefore, hold on this matter. All that, my lords, have purchased property in 2021, my lords. Sale certificate issued in 2021, my lords. Till date, I am unable to get into possession, my lords. This is the 16th petition filed by them before this court, my lords.
28.
Deeply obliged, my lords.
No time will be granted, Mr. Counsel. Any further time? If your senior is not available, you argue on that day. Correct?
Please.
This is complaints in contempt matters. Seal number 17. Chandrakant Argole.
I appear to the accused in this matter. So the complainant in this matter, my lords. Complaints affidavit has been filed in this matter, your lordship. The matter pertains to conduct of elections to the society, my lords. Now, the accused have filed their complaints affidavit stating that they would conduct elections by the end of August 24.
Good enough. Learned single judge passed direction in his order dated 9/2/23. Disposing of the writ petition, directing disposal 3. That's the district registrar of societies, Hassan, district Hassan. To ensure that the elections to the petitioner Sangha are conducted in accordance with law, are conducted expeditiously within 2 months. Telegraph. Learned while learned advocate for the it is this directions which are brought under the contempt jurisdiction. of this court by filing this contempt petition paragraph. While learned advocate for the complainant, Mr. So-and-so would submit that the state order was passed as back as on 13th September 2023. The steps are not taken within the time indicated by the court. From a learned, additionally, the government advocate invited details of the court to the compliance affidavit filed by the response 3, in which it is stated that the elections will be conducted and completed. Yes. Latest in the last week of August 2024. Full stop.
If I may seek
So
one.
belatedly, paragraph. The compliance of the directions are obtained, therefore the court closes the contempt proceedings with observation that the elections are not held as indicated in the compliance affidavit. The respondents will be exposed to the aggravated form of crime.
A pleasure, much obliged.
Number 18. To Srikanth.
Petition.
Appearing for respondent number 13 in this matter.
But the matter relates to, my lords, admission of a student, my lords, to a medical college, that's government seat, not under sports quota. My lord, the writ petition was filed, my lords, when, my lords, the counseling process was, my lords, began the last year, saying that I should have been considered and, my lord, my lords, my ranking should have been made as P1. Applying the rules, my lords, which are, my lords, issued by the government, and my case should have been considered. My lords, was my request, and my lords, was when the writ petition was filed. Unfortunately, my lords, both, my lord, the contesting respondents, that is, my lords, the KE as well as, my lord, the Department of Youth Affairs and Sports, they did not file contempt, my lord. The matter went on, my lords. Now I am standing in the next year. My lords, insofar as whether my claim can be made as of now, my lords, insofar as the seat for the last year, my lords, I would, my lords, answer that contention. My lords, I'm also supported by, my lords, another edition of this honorable court where it says it can be adjusted. My lord, the objection which has been handed over to me, my lords, by the state, that is Department of Youth Affairs and Sports, my lords, day before yesterday, my lords, I'm not sure whether it is put up. My lord, raises mainly, my lords, two grounds for non-consideration of my case. One is that, my lords, though I say that I won gold medal in an international event, that is Asian Youth Chess Championship, they say it is beyond the cutoff date as per the notification issued by them. That is the first ground. The second ground, they say why I am not considered is for the reason that though I produced the document before this honorable court, saying that my candidature was sponsored by, my lord, All India Chess Federation, they say there is nothing which says that you have represented the country in the international event. These are the two major objections, my lords, raised by the state, my lords. And my lords, KEA says last year selection anyway, it says that department is responsible. My lord, now, my lords, others, my lords, who were admitted, my lords, in the sports category, they were, my lords, impleted, my lords, by way of an application, my lords, a formal order to be passed, my lords, insofar as the application for impleading is concerned. But however, my lords, all are present, my lords, they have, I mean, some of them have also filed the counter. But these are, my lords, the broad issues, my lords, insofar as the case is concerned. If I'm permitted, my lords, the petition, my lords, filed by me, the very contention, my lords, I have taken. If lords kindly come to, my lords, page number 31. My lords, is, my lords, the invitation, my lords, issued for, my lords, representing, my lords, and participating, my lords, in the event. The first paragraph, my lords, of page number 31 itself, if lords kindly see, my lords. I'm answering not the contention that not I represented the country, and not I'll also answer the contention that that is not my case request to be considered. Page number 31, notes annexure E, notes for a month. Lots are having page number 31 minutes. Which is notes an invitation. Issued notes first paragraph reads, the Thailand Chess Association in cooperation with Bangpi Chess Club and under the auspices of the Asian Chess Federation and FIDE. Lord, it clearly says, Lords, FIDE is involved, Asian Chess Federation is involved. Lords, and the event is being conducted. Now, my lords, if your lordships kindly take, my lords, the next document. If your lordships kindly see, my lords, annexure F, page number 36, is the communication, my lords, of All India Chess Federation, addressed to, my lord, the Thai consulate, saying that these are the participants, coaches, who are going to, my lords, participate in the championship. As such, they request, my lords, for issuance of visa. This shows that, my lords, All India Chess Federation was involved in even ensuring visa to be issued in respect of the participants. Your lordships may kindly come to, my lords.
Where is your objections are filed?
Yes, I have filed my objection.
Where are they?
My lord, that is, it was filed on 26th of July, my lord.
26th of July.
July, yes.
KA, my lords, has filed, and the state, my lords, I was provided with the copy day before.
State has to, but with the authority. It's the
I'm
last
answering,
case.
my lords, the contention of the state only. If, I mean, with the assumption that, my lord, the same is before your lordships.
So who are proposed respondents?
My lords, those, my lords, what I, as I submitted, my lords, I came before this honorable court in the beginning, before even the counseling. Thereafter, my lords, as
Where is this KE's reply? It's not. This reply of number 30, respondent number 13 is there.
Yeah, I appear for respondent number 13 in this
Where is
case.
the reply of
Mine is the first,
KE?
first respondent. Was there now?
Statement of objection number 1, you are number 1. Yes, it is.
Yes.
It is there, yes.
Yes.
My lords, if maybe, I may be permitted to take.
Second respondent is university.
No, my lord, that is
that
the
is
government.
government,
Department of Youth
Youth
Service.
Affairs and Sports.
They are the ones, my lord, who categorize, my lord, and give the assigned ranking, sports ranking.
You have filed your affidavit?
Okay. I filed on the 20th.
20th,
On 20th August.
20th August. Fine. 28th August.
20th of August. You think? It's yesterday. Yesterday, my lords, it seems they have filed. It filed yesterday. Yesterday.
This rule 9 was amended. When?
It's, Rule 9 is amended for this year, my lord.
For this year.
This year, my lord. In fact, yesterday, my lordships had the opportunity to decide one case where interim order was granted.
Yesterday, which was that matter? We dispose it of.
Interim order was.
Interim order was passed. We just get the papers of that. The rule, amended rule is there in that.
Please.
Amended. Amended from 24. This 16/3/24. So as per the amended rule, he will be entitled, possible.
Rules
are
amended prospectively.
So because your ground is that the student did not won the medal.
He
Here
did
in
not
the
win the
amended rule, only participation is the criteria.
Please, my lord. And those participation is not that he's represented the country.
At that time, the winning of medal was the requirement.
Please.
Lords, my submission is that, Lords, the contention of the state appears to be, Lords, saying that though you have been sponsored by All India Chess Federation, Lords, appeared in the event, Lords, which was conducted, Lords, where the FIDE was involved. It does not say, Lords, does not mean that you are not, Lords, representing the country. Or rather means that there is no material on record. That is the contention.
Lord, even
But
assume.
So
Lord,
they are
it is-
saying that under rule 9, then prevalent.
My lords, in fact, my lords, the issue, earlier, my lord, there was no compliance. On my petition, one of my petition only, my lord, the issue was taken up. Directions were issued, my lord, the entire thing was being regulated. Direction was issued to redo, my lord, the list, my lord, in the, that is the, my lord's, previous years.
So what is your case?
My lords, my case is that, my lords, it is a fact, my lord, that I represented the country. And my case comes within the provisions of Rule 9(1)B of the rules.
9(1).
B, my lords, capital B of the rules.
What is that? Let us see.
My lord, that has been, my lords, extracted by, my lords, the state in their objections. My lords, may I have a look at page number 2, my lords?
It is extracted by this.
My lord, state, my lord, that is
state, yes.
respondent number 2.
Yes.
I have also filed. They have it, that's.
Anywhere.
My lord, we kindly see page number 50 of the writ petition, my lord, the entire.
I have,
rules are
my lords,
produced.
I have
Showing
reduced the rules,
candidates
my lords,
eligible.
in my petition.
Who have represented the country and won medal.
Yeah, my lords, my lords, I'll answer, my lord, those contain, my lord, that requirement. There are two things, my lords, which are to be, my lords, noticed in the rules. One is, my lords, as your lordships rightly pointed out, my lord, I represented the country and won the medal. Number two is, my lords, it only says during the 5 years period of study in Karnataka between 8th to 12th standards. They are not the requirements. The objection of, my lord, the state is that there is no material placed on record to show that you represented the country, though you claim that you have won the medal. Number two, you say that you got the, my lords, the gold medal in an international event, but it was held prior to 1/6/2018 of that year. That is the cutoff date we have provided as per the notification. And as such, it cannot be considered, my lords, is the sum and substance of their case. My lords, that's the reason, my lords, if I'm permitted, my lords, I may rely upon, my lords, a few decisions and also certain documents to show that, my lords, what the argument of the other side is, my lords, on a hypothetical basis, saying that, my lords, asking the cricket team, yes, you might have represented in international events, won World Cup, but what is there to show that you represented the country? Because the team, my lords, is my lords, is selected by the BCCI, that goes and wins the, my lords, events. Similarly, my lord, Indian Olympic Association, my lords, selects candidate, my lords, they go and, my lords, participate in Asia and also, my lords, the Olympics. Then, my lords, the argument of the other side seems to be that, my lords, there is nothing to show that you represented the country, and unless and until there is a certification by the government of India.
What is your stand? Let us.
My lords, I'll answer, my lords, that issue, my lords, if I'm permitted. My lord, the constitution, my lords, of both, my lords,
Paragraph 4, so petitioner claims that he is entitled to be considered as P3 and not P5.
my lord, that was the, my lords, initially I said P3, but later on, my lords, I said, considering that
Applied
event,
only
I
to
should.
those students who have won medals in B games.
Medals in B games specified in Schedule 2 by representing the state of Karnataka and participated in Super A games or A games specified in Schedule 2. Lord, there is a twofold requirement. One is they have to win medals or cups in B games and participated in Super A games, which they are not entitled to.
Yes, what?
Please, my lord.
What you reading where?
My lord, the same rules, my lord.
Rule 9.
Rule 9B3.
My lords, I have produced the
9B.
entire rules, my lords, in my petition. My
Who have
lord,
won medals in B games.
Who have won
Specified in
medals,
Schedule
cups in
2.
B games specified in
Representing
Schedule 2.
Karnataka state and
Please.
participated in Super A games or A games. Specified in Schedule 2 during 5 years period of study in Karnataka between 8. So he is not falling with.
He is not qualified for that. My lord, now 4, P4, who have represented Karnataka state in B games specified in Schedule 2 and won medals, so cups during the 5 years period of study in Karnataka between 8th and 12th standard. This is what they are relying on. My lord, their medal, what they won is beyond the cutoff date. It is prior to the cutoff date. And whatever they have participated, my lord, in some championship which they claim in Chiang Mai, Thailand.
But they are not entitled to under clause 4.
my lords, my.
They have not
submission
won
is that,
anything.
My lords,
My submission is that they have not won anything. They have not won a cup or a medal.
But that winning of medal is not the requirement here.
my lords, that my lords is, my lords, an incorrect submission which is made. If your lordships are having, my lords, my writ petition, my lords, page number 60. I have produced the entire rule, my lords, for the consideration of this honorable court.
That is the requirement.
Let me. My lords,
Whoever-
what the rule says.
No.
Is, my lords, the.
Let us complete this.
Please.
Yes.
In fact, my lord, the fourth one says, who have represented Karnataka state in B games specified in Schedule 2
Won medals.
and won medals or cups during the 5 years.
Now what is your say? That is.
My lords, may have a look at, my lord, the relevant rules itself. My lords, at page number 60, my lords, of my writ petition. My lords, I produced the entire rule. Requirement is, my lords, who have represented the country and won medals, cups in the Super A games specified in Schedule 2 during the 5 years period of study in
Where-
Karnataka between 8 to 12 standards.
Reading what?
Please, my lord.
What are you reading?
My lords,
You are reading what?
my lords, the relevant rules, my lords. My lords, 91B, my lords, 1. Page number 60, my lords.
Page number?
Page number 60, 60, my lord. My lord, the entire, my lords, the rules, my lords, which, my lord, starts. Page number 50 onwards, my lord, the rule is produced, the entire rule is produced. If lordships kindly come to my lords, page number 59, my lords.
Oh. So which are these rules? Same rule?
Yes, my lords. Same rule, my lord, they produced, my lords, the text. They have extracted the rules, my lords, in their objection. I have produced the, my lord, the text of the rules itself.
Oh, so which?
My lords, 9(1)(b), my lords, small Roman 1, my lords.
Oh.
The following candidates shall be eligible for selection under sports category, namely, who have represented the country and won medals cups in the Super A games specified in Schedule 2 during the 5 years period of study in the Karnataka between 8th to 12th standards. My lords, the requirement is, my lords, that I should have represented the country, one medal, insofar as the event, my lords, which is provided as per, my lords, the schedule or, my lords, the Schedule 2 to the rules. My lord, Schedule 2, my lords, if your lordships kindly take, my lord. At page number 67, my lords. The event, my lords, in question is, my lords, Asian Youth Championship.
Schedule 2, yes, 66.
67.
So you are according to your calling in which clause?
My lords, the Super A games itself, my lords. And even, my lords, for a moment, I'll be under, my lords, A games, because
No, you're
international
calling-
meets.
Firstly, let us see 9(1)(b).
Please,
Which clause? Which clause?
My lords, I am, my lords, eligible under small Roman 1 and 2 also.
1
But
and
I
2,
would, my
1
lords,
and 2
establish
both.
that.
So
Lord, as read to your lordships, my lords, insofar as small Roman 1, is that, my lords, I have participated in an international event, my lords, and secured the medal for the country. Now, small Roman 2, my lords, who have represented the country and won medals cups in A games specified in Schedule 2 during the 5 years of study in Karnataka between 8th to 12th standards. My lords, my submission is that, my lords, for a moment, my lords, if they say that you don't come under Super A games, still I'll be classified under, my lords, A, my lords, category. My lords, may have a look at, my lord, the schedule, my lords, Schedule 2 to the rules.
So you are to be classified in Super A game.
Super A, my lords, all, my lords, according to me, my lords, come, Super A, my lords, for a, my lords, it's a debatable question. Because, my lords, it says, what I have participated, my lords, is Asian Youth Chess Championship. My lords, as per Super A games, it lists, my lords, Olympic Games, World Championships, Asian Championships, Asian Games, Commonwealth Games, and Commonwealth Championships. Whereas, my lords, A games mentions about international meets. According to me, my lords, I qualify under both. Even for a moment, if it is held that I don't come under Super A, I definitely come under A is my submission. Now, my lords, insofar as the contention of the other side, that, my lords, I did not represent the country, or there is no material to show that I represented the country. Lords, if I'm permitted, my lords, it would be necessary in those circumstances, my lords, to look into the constitution of FIDE as well as, my lords, All India Chess Federation.
Mutation cups, my lord, mutation events.
I don't come under invitation event, my lords. That is my case.
Mutation, 9(1)(b). 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 9(1)(b
Please, my lord. Produced it in my objections, my lord. There is a circular.
My lords, the rules are explicit. It says period of study.
But where the cutoff date, my lord, is from 1st June. Circular I have produced, my lord, with my objections. Page. In vernacular, it is at page 17. Translated copy is at page 18. In fact, my lord, the second point, my lord, is clear. No, my lord. My lord, even assuming that the cutoff date issue is not accepted, it has to be known whether he represented the country first. The thing is that.
I will answer, sir. My lords. Yes, my lords, may have a look at my lord, the certificate, what I am relying upon. To show that, my lords, I am, my lords, entitled annexure D2, my lords. Page number 27.
My lord, my lord, just one submission, my lord, insofar as annexure D2, that is where the dispute lies, my lord. It does not come within the cutoff period, what we have specified. That is one aspect. And the other aspect, my lord, if you, my lord, it does not satisfy the cutoff dates, my lord.
They say as
In what they claim. Other than that also, my lord, this, as per our circular. And other than that also, my lord, it doesn't say that she's a winner of Team India or anything of that sort. No, my lord. Circular just mentions the date, my lord. It starts from 1st June to 31st May. That 5 years is what the circular mentions.
rules are clear, period of study.
Within that 5 years. Please. Participate and have won the medal.
Between 8 and 12.
So what is the date between 8 and 12? Is there a rule?
That there, my lords, they are not entitled to say when the rules are there. My lords, I may permit it to my lords, my lords.
Well, the rules specify for 5 years and we have just mentioned the dates.
If your lordship
My
may
lords, may
kindly allow
permit
me to
me, my
make
lords.
submissions.
With my lords may permit, my lords, I have, my lords, the constitution of the, my lords, FIDE as well as, my lords, the All India Chess Federation, which goes to show that, my lord, that is the FIDE, that is, my lords, the international organization, has member countries which have, my lord, the recognition of the respective countries and will be representing those particular countries. My lords, the CSM, that is All India Chess Federation, my lords, also says in its, my lords, regulations that they will, my lords, select and send the candidates to international event representing the country. My lords, I have, my lords, a decision of the Honorable Supreme Court to show, my lord, what is happening is, my lord, the rules are clear. It says period of study. But, my lords, they are prescribing, my lords, a time limit that is 1/6/2018, and they say till that year. My lord, prescription of 1/6/2018 or the date, my lords, from 1st of June is, my lords, contrary to the language or what is there in the rules itself. When the rules are clear, when it says period of study, my lord, they cannot say that this is going to be the cutoff date. My lords, if at all they wanted, they would have, my lords, made a, my lords, carried out the amendment said between those dates. But what the rule says cannot be restricted, my lords, by way of an administrative instruction. And, my lords, I am supported by a decision of the Honorable Supreme Court, my lords, to that effect. Insofar as representing the country,
You wherever,
my lords,
whatever you want.
my lords, I mean,
Also one submission, my lord. Now whether
sorry.
problem is not same federation Lord, will conduct so many events. Some are international events, but international event doesn't mean to say Lord, that is a
the candidate is representing the country. The
Lords,
invitation comes are
Lords,
also
I
there.
can Lords, I can understand, my lord, if this submission is made by the state. The K is on record to
No, I
state.
just told
One second.
Assisting the court. my lord.
It only says, my lords, I follow whatever the government says.
What is your submission?
My submission, madam, now the chess federation not conduct so many events. Some of the events are international events. They go. International events doesn't mean to say all international events where these candidates are representing the India. The invitation cups are there, they go. What the statement of objection says is that's the invitation cup. He has not represented the country. If it's representing the country through the federation, my lord, yes.
That is what my answer
Not
is.
representing.
In fact,
My answer is yes, I represented the country.
in fact, my lord, the All India Chess Federation is served unrepresented, but they've issued this letter. My learned friend had passed on to the court. This says that it is certified that so-and-so with current international rating so-and-so participated as a special entry in Asian Youth Championship, Thailand. From,
What are you reading? Give us.
my lord, I think he's produced, my lord, this is one of the letters which the All India Chess Federation is.
All India Chess Federation is a party, but they are not represented by anybody.
This specifically answers that Annexure D2 certificate.
No. I will answer. It is my petition, I will answer.
Please do so.
You give in a form of separate sheet your details of participation. And a year away, both of you, tomorrow,
Please,
for that purpose only. Then we'll take a call.
please,
Tomorrow at 2:30.
please.
You to me. At least about participation, factual aspect of participation, there should not be a dispute.
Participation will come down, my lord.
So then you give both of you so that it is admitted fact, what kind of participation.
My lords,
One medal is.
my lords, apart from that, my lord, there's no dispute, my lords, by them.
No, then.
If you go to
then-
participation in state events and national events, they say you have participated. We classify you as P5, but not as P1. We don't recognize your medal, my lord, is their contention.
In fact, the participation details have also produced by objections.
You give it in separate sheet.
Please, my lords, I'll answer, my lords. In fact, my lords, whatever the documents on which I am placing reliance upon, my lords, I have, my lords, I filed it just now, my lords, I'll file a synopsis and my lords, I'll make submissions on that. Published.
Yes, number 20. So Madhukar M. Deshpande.
Speak for the appellant, my lord.
But I am for the respondent. Kindly.
Compliance of the office objection, my lord, and an order was, preemptory order was passed. And earlier to that, my lord, during the vacation, I had moved the matter and an interim order was granted. I have filed an application for recall of the order of dated 4/6/2024, my lord.
IA 5 of 24 heard learned counsel for the respective parties. It appears that the writ petition was dismissed. Writ appeal was dismissed on account of order dated 4/6/24, which provided for removal of office objections within stipulated time, which could not be adhered to by the appellants. Full stop. Learned advocate for the applicant appellant, Mr. So-and-so stated before the court that whatever office objections are left out from being removed shall be removed within the time which the court may grant now. Full stop. In view of the said statement and in order to enable the appellant to contest his case on merits rather than being thrown out on technical ground of office objections, the application is allowed by restoring writ appeal number 752 of 24 to its original file with all orders subsisting therein on condition that the left out office objections shall be removed within 10 days.
Interim order.
Lords, it's a case of a
All are
handicap.
revived. Everything is revived.
Yes.
May I request for a date to be fixed, my lord. It's a case where a pathetic condition of the respondent, which is amplified in the judgment.
My lord, it is dispute relating to non-payment of the HRA allowance, my lord, because he is already provided an guest house accommodation. Since he is occupying that particular guest house
But
accommodation.
he is misrepresenting the fact.
Appeal shall be
Kindly
listed on
see
20th
para
September.
8 and 9 of the honorable single judge's judgment.
Till this date, the last date, my lord, that.
Please,
Since
Please,
the
brother.
revival is directed with, along with the substituting order, the interim order shall operate.
Much of.
A date when
Court officer? Court officer? Ratio?
ದೊಡ್ಡ ಮನೆ ಕಟ್ಬೇಕು. ಇನ್ನೊಂದ್ 2 ವರ್ಷ ಸಿಕ್ಬಿಟ್ಟಿದ್ರೆ ಪಾಸ್
Court officer? Court officer, am I audible? Court officer ಕೇಳಿಸ್ತಾ ಇದೆನಾ? Hello?
submission. But serial number 74, the contempt petition. That there is a clear direction of the Honorable Court to the Deputy Commissioner, the State Tahsildar, to take position. The builder is already constructed the building. Now by virtue of the order, some of the purchase of the property, trying to sell to other parties, innocent people. They're losing the money. That's why, my lord, the office raised some objection. That has been clarified. Now, if this honorable court, my lord, request great respect, I am requesting all, if the notice has been issued, the Tahsildar and the Deputy Commissioner will take action. Otherwise, they will do some illegal activities in this property.
Date is for office of this.
Office of, but
So remove it.
respondent, see, there is a 4 respondents. One is,
We will say that if office of this, the learned council states that the office of this is removed.
yeah, that's why, respect of R3, I'm filing the memo for R3.
File there.
And even if the respondent number 3 in the petition, there is no harm to the cause to anybody because he's a formal respondent number 3 in the proceedings. But there is a direction by the honorable court only in respect of respondent, accused number 1, 2 and 3.
Strike. Pending removal of office objections, comma, the contempt petition may be listed on Monday.
Great. At least notice has been ordered, my lord. At least if notice goes, then they will not take any action.
Today it is in office objection board. When it will listed for admission, we'll issue notice.
Lordship order to put this matter for admission.
You can't be, you can't chart a different course. It is listed for office objection today.
That's why I clarified the
So
objection.
Monday it can be listed. We will dispense with the office of the time being. So what did you read? Pending the removal of office objections, the contempt petition will be listed on Monday for admission, on admission.
Monday is a holiday, Your Lordship. Tuesday, Your Lordship.
With my lord's kind permission, my lord, serial number 26 has been set down for filing of reply. I appear on behalf of the accused contemner, my lords. I have already filed the reply in the registry after serving on the opposite side. May kindly be adjourned for hearing, my lords.
Adjourned to which date?
My lords, any day convenient to this honorable court.
18th September.
Faithful, my lords.
Monday. Monday is government holiday. That's why I take on Tuesday. Monday is government holiday.
Yes. First 2:30 and click back and then that.
Ashwini, wo?
Appear for the complainants in this matter, my lord. This matter pertains to the enrollment, non-enrollment of my clients, my lord, by the Bar Council, the
Not,
state. Bar Council.
that may not produce a subsequent judgment.
It is.
Para 109 minutes, page number 38 minutes.
Number?
Para number 109 minutes, last conclusions. Lord's colleague. In view of the above discussion, we conclude that State Bar Council cannot charge enrollment fees beyond express legal stipulation under section 24(1)(f) as it currently stands.
My lord,
It is all right, but why don't you give registration?
with due respect, my lord,
No, no.
the Supreme Court judgment does not, in fact, it would be irrelevant for the current purposes because this honorable court has ordered them to enroll us.
No, no. May
Irrespect-
may just take notes order is concerned. Or as the case may be decided in terms of decision of the Honorable Supreme Court in petition number so on. So.
My lord, the entire paragraph may kindly be read. Ad interim direction is issued to the
Are you enrolling or not now? No.
But we are, my lords, we are about to follow.
You are enrolling. Why you are harassing the student?
No, no, it says not.
This has nothing to do with the direction,
nothing
Mr.
to do with
Counsel.
the direction, my lord.
No, 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 it says not the subject.
Don't mislead the court.
No, no.
We are not that naive. When you are enrolling,
We'll,
this is absolutely wrong submission on your part. And you are appearing for bar council.
Please.
Bring the secretary here.
Maybe just,
Today, right now. Bring him.
I'll.
Bring him right now. Why should he is not granting registration to the student, enrolling the student?
No, in the meantime, since the Supreme Court judgment says, no, with respect to
Supreme
collection of
Court
fees,
judgment only fixes the fee,
Please,
about fee.
please.
Now this direction, he will pay the fee, whatever you charge.
Yes, my lord.
we'll call upon minutes, enrollment applications will be called upon. Notes will be sent for the scrutiny. Accordingly, notes will follow the
Shall
procedure.
we say that you are misleading the court
No,
by citing this judgment?
no, but it says, since it has been referred, not
Want us to observe that you are misleading the court?
my apology, so that, my apology.
Where is the question of apology? You are thoroughly misleading the court. This has nothing to do with the directions.
No, it says not subject to result, that's the reason not I produce.
This doesn't give you license not to comply with.
No, no.
On the contrary, the fee is lessened. You
No,
are supposed to
that's
charge
the
less
reason.
fees.
That's the reason my side, so far the fixation of fees is concerned.
Now, when you are complying, when you are come to tomorrow with the registration, grant the enrollment to him, to her,
Not really.
tomorrow itself.
No,
The secretary of the bar, which is the one, shall remain personally present. Do you want that?
no,
We'll pass the.
I'll just intimate,
Huh?
I'll just intimate to the bar council.
My lord, four.
So far as-
Council, don't mislead the court
No,
by
no.
citing a wrong judgment.
No,
This has nothing to do with the non-compliance with the direction. The Supreme Court judgment doesn't absolve you in any manner whatsoever from compliance.
not, it says, it fixes not the enrollment fee. This issue pertains to not fixation of enrollment fee. That's the reason.
For
not fixed.
enrollment, she will pay the fee, whatever you charge.
That's the reason. Supreme Court now has said that this is what the fixed fee has to be fixed up.
Charge whatever you understand.
Now
And
we'll
therefore,
comply.
if you-
Now we'll comply. We are bound by what's the order being passed to Supreme Court. Now we'll certainly comply.
Again,
Because-
you are saying same thing.
No, we have to call for minutes for all the invite minutes applications. We have to take the application.
We are passing the.
My apology. I'll just not say. Intimate minutes of the bar council. Because we are bound to follow minutes of procedure. We have taken the application.
No, tomorrow you will come with the enrollment. Whatever procedure you want to follow, follow.
I'll intimate more to the bar council. I'll intimate more to the bar council.
Hmm?
I will intimate more to the bar council.
There is no question of intimating. You obey the court's direction. No question of intimating now. The stand is too much, Mr. Counselor.
Well, I will.
We are
all the-
ready to give you the time to comply with, but not the after misleading the court.
No, there's no misleading.
This is what else it is.
But that is not in passed in the month of 30th July. Not it says with respect to the
And
enrollment.
not the
fixation-
Mufasil court, where you can submit anything and anything, which is entirely unconnected.
Since it is referred in the interim order, that's the reason what I
Or
produced.
we put the high court and the first court, and you are misleading the court by relying on this judgment.
No, it has been referred not in the interim. order.
Comply with, mister. We'll give 1 day more. Day after tomorrow at 11, you must come with the enrollment.
At least 1 week's
Have
time.
to come. There is no option. There is no option because of your conduct.
No, it has been referred minutes in the interim order. May I apologize? I'll come in. I'll come in.
Objections. So, in the order dated 9th May 2024, passed by learned single judge in the writ petition number 13018 of 2024. Is to enroll the how many petitioners are there?
2 petitioners.
Enrolls the two petitioners to the State Bar Council, subject to the petitioners furnishing an undertaking that they would pay the enrollment charges as may be determined by this court, or may be decided in terms of the decision of the Supreme Court, Honorable Supreme Court in writ petition into writ C, number 352 of 23. Full stop. The Supreme Court has already rendered its decision in Gaurav Kumar in the said matter, which is reported as 2024 SCC online SC 1841. Full stop. Learned Advocate Ms.
Ashwini.
States that the petitioner shall pay the enrollment charges as may be required, as may be required.
As per the
Tomorrow-
Advocates Act.
tomorrow
my lord. As per the Advocates Act, my lord.
As per the law. Tomorrow itself,
Today itself will pay, my lord.
today itself, full stop. In that view, comma, the respondent bar council shall comply with the direction and enroll the petitioners, full stop. The compliance shall be reported to this court on 20. Today is Wednesday. 23rd of. When?
Tuesday, 27th, 27th.
On 28th. On 28th of. Don't.
No, no, no.
Hence for
No,
indulgence.
the very Supreme Court order being referred in the single judge's order, that's what minutes I produced.
Don't force to go angry in the court. On 28th of October. Full stop. If the directions are not complied with, the chairperson of the Karnataka State Bar Council shall remain personally paid. Secretary of the chairperson. Secretary of the Karnataka State Bar Council shall personally remain present to explain the conduct of non-compliance.
Please.
My lord, 24th
release-
of October, my lord. 24th of October, my lord.
No.
I think my lord's dictated October,
August.
August.
This is all out of anger. Some Wednesday, next Wednesday.
Please, certainly.
Obliged.
Number 61. This is a
For respondents,
for complaint.
I pressed time to file a reply, my lord, in this case, my lord.
What is it?
There is an order for reinstatement of the
Where?
Order is at Annexure A, my lord. Operative portion it is at page 22.
Not reinstated?
My lord, I pressed time to file reply, my lord.
Play.
Reply. And my lord, in the meantime, my lord, we have sent a letter to the complaint on 1/8/2024, reinstating her appointment.
You are Rajiv Gandhi.
No, my lord, Rajya Vakkaligara Sangha.
Rajya Vakalinga.
Sangha, and Dental College, VS Dental College,
So that's a college.
yes, college. We have sent a letter on 1/8/2024 for reinstating the complaint, my lord.
What reply will file? You have to reinstate.
And with all consequential benefits, my lord. Reinstatement with all consequential benefits, my lord.
Pardon?
Reinstatement with all consequential benefits.
All consequential benefit.
In that, in second part is concerned, we are preferring appeal before division bench, my lord.
Preferring appeal.
Yes, my lord.
Is it filed
Yeah.
or not?
Not yet preferred.
Appeal is filed.
We are preparing, my lord.
Preparing means what? We are also preparing to direct you to remain personal. You prepare appeal, now we prepare you to remain.
Reinstatement order already issued. Reinstatement order already issued on 1/8/2020,
Statement is already issued.
issued, my lord. And served.
Reinstatement order is issued, but not the consequential benefits, my lord.
Of learner single.
I'm entitled for consequential benefits also, my
Two
lord.
parts. One is for reinstatement of the complainant, the other for payment of consequential benefits, paragraph. Today, learned advocate Mr. So-and-so. The respondent stated that the reinstatement is already ordered and the complainant is reinstated in service. learned advocate for the complainant, Mr. So and so could not dispute the statement that the complainant is reinstated. First of, as regard the second part of the direction to pay the consequential benefits, it was submitted by learned advocate for the respondents that the respondent decided to prefer appeal.
Please, my lord.
First of, in that view, the present contempt proceedings
My lord, contempt may be pending, my lord.
stand deferred to be listed next on 30th, on 25th of September.
Please, my lord. Grateful.
List number 2, the passport matter seal number 1, to Mallikarjun R.
My lords, this morning I referred to page number 49, my lords. My lord, this is a case of a KL institution having made an application to the central government to consider the application where I have sought for enhancement of post-graduation seats in dental from 2 to 6, my lords. In fact, my lords, as per the notification.
After the directions by the division bench, it has been considered and rejected by the respondent.
Pardon?
After the directions issued by this honorable court, my lord, we have considered the representation and rejected it.
Where is that?
In fact, I furnished a copy, my lords. I also furnished a copy to my brother counsel, my lords. My lords, in fact, my lord, this is the document what I supplied, my lords. It is dated 28th of May, my lords. This order came to be passed by this court on 23rd, my lords. Immediately, my lords, obtaining certified copy, I approached this central government, I moved this, my lords, along with the certified copy of order passed by the court. In fact, my lords, I have given the representation, my reply on 18/7, my lords, which is the next page. I may permit to read. I am directed to refer to the above subject mentioned and to say that your application dated 28/5 so-and-so was examined in the ministry. It is informed that as the application or beyond the timelines, application cannot be accepted. You are requested to apply for the scheme next year within the due date as per the notified time schedule. This issues with the approval of competent authority. My lords, in fact, my lord, this representation or the reply given by the government, my lords, it has not considered the direction given by this honorable court, my lords. In fact, my lords, I have moved this along with the order of the copy court, my lords. In spite of order being conveyed to them within 3 days from the date of the order passed by this court, my lords, they have given this reply dated 18/7, my lords. My lord, this is the reason, my lords. In fact, I got your honors to the page number 49, my lords, that the time period to consider the application, whether I have completed all these things, are till October, my lords, October 30th. My lords, all that is that, my lords, whether 2 days of delay would really take away my right to seek for enhancement of seat, my lords. In fact, my lords, this morning when I taking my lords to this page number 49, my lords, there the 49 itself says, my lord, note number 2, that the time schedule may be varied as the central government may decide, my lords.
You are for whom?
Respondent.
Which is?
Union FPT, one respondent. There's only one respondent.
Only one.
Yes.
But then you place on record, why you are passing the same order without any reasons?
No.
See all.
The time schedules, my lord, has to be strictly had to be added. There's a catena of judgments of the Supreme Court only, my lord. Because it will upset the entire academic this thing, my lord.
Beyond timeline.
Because there is series of judgments, my lord. I'll file my counter, my lord. A week's time may be granted, my lord, please.
My lords, by considering my application, my lords, no prejudice is going to be caused to the government, my lords. For the simple reason, my lords, may I take my lords to page number 49, my lords. My lord, the process is under still going on, my lords. In fact, my lords, when I move the application, the deadline was, my lords, April 7th, my lords. Though I have dispatched the application on 23rd of March, my lords, it has reached on the 9th of April, my lord. That is 2 days beyond the period, my lords.
By order dated 23rd of May 2024, the respondent Union of India was required by the court to consider the application dated 25/3/24 filed by the petitioner. In which the request of the petitioner was to permit the increase in the intake capacity of seats from 2 to 6 TWO to SIX in the existing MDS, in the MDS course, in the specialty of conservative dentistry, DNTI-STRY, and endodontics, DNDO, twice DODO, and TICS for the academic year 2025, 26. And the proceedings of the petition come up for consideration today. Learned advocate of the parties used before the court, produced for perusal of the court. Order dated 18/7/24, passed by the competent authority of the Ministry of Health and Family Welfare, integrated dental education section, bracket over Government of India, by which the application dated 25 public 28/5/24 came to be rejected on the ground that it was beyond timeline. Paragraph. The aforesaid communication and the decision taken in the nature of subsequent development is a separate cause of action in itself. It will for the petitioner to take appropriate steps.
My lords, may I have one submission, my lords? May I permit it to give one more presentation to let the, my submission is this, my lords. I may permit to give one more representation. Let the respondent consider this application in view of the direction passed by this court, my lords. Because, my lords, this never speaks that we have considered the direction passed by High Court, my lords.
Challenge. You challenge by whatever, by separate petition, by amendment, whatever.
Since, my lords, it is during the pendency of the petition, my lords.
So you place on record.
Please, my lords.
Challenge it in whatever way you want to challenge, then we'll deal with it.
One more question, my lords. I would have moved the representative tomorrow, my lords. They would have considered that my representative right because we have time, my lords. This is not going because the academics for 25/26, my lords. Till we have May, my lords. Therefore, my lords, by this time, the central government have moved the application to the DCI, my lord, the Dental Council of India, my lords. It was that stage, my lords. So therefore, my lords, if I may permit to give one more representation to consider the representation in the light of the order passed by this honorable court, my lords, probably they may consider, my lords. That is the reason, my lords.
Whatever you want to do after placing on record or filing separate petition is a new cause of action. You are faced with a new order.
No, but this order is based upon the direction passed by the Honorable Court, my lords.
Be on record before we can take cognizance of. Right?
I am permitted to move on representation also to,
Whatever you,
may be reserved, my lords.
So you do it, we'll deal with it.
My liberty may be reserved.
Number, list one, seal number 36.
But who is your opponent? Therefore, we said tomorrow or day after, because unless they know how they will come. Did you inform that it is going to be taken away to?
There is an office objection with regard to the vacating of stay, my lord. In fact, that has been rectified and we have got the vacating of stay as per the rule prescribed. I can have that filed, my lord. And the learned AG will be appearing in the matter.
Yes, who is appealing?
Subramanya R. Vinayak B.
In fact, the portion of the order has been,
When the 3 years term?
my lord, in this, that issue may not arise, my lord. Because I went through the records, they have not maintained that 3-year period, unlike the Raj and the university. My lord.
They are maintaining 3 years.
That, no, the act says 3 years, but from the records, we don't know when there's a 3-year period, my lord, because I'll not be able to make a submission. It may be factually incorrect if I make any submission, because I'm not able to give the correct date when it gets over 3 years.
Correct date of?
Completion of 3 years. my lord. Just one short point in this, can I request your lordship?
Take your time.
I'm sorry, it came.
We'll take up one matter in it.
Please.
Yes.
Number 21. Shivshankar C.
Here we have got the contempt of the order passed by this honorable division bench. Though there was a specific direction to make the revenue entries, my lord, and then subsequently, my lord, on 2 dates, when this matter was listed before this honorable court, on 24/4, time was granted for them to file the compliance affidavit. Then the matter was listed on 16/7/24. On that day also, my lord, they said that they will comply with the order. my lord, 4 weeks time was given to them to file compliance affidavit. My lord, the operative portion of the order is at page 169, passed by this honorable court. We have been making representations saying that an order has been passed by this honorable court. We have also said that your government advocate has taken time to file compliance affidavit. Kindly comply. In spite of that, there is no compliance. The last order was on 16/7. This honorable court passed an order on 22/1/24.
So you are for mutation of entry.
Yes,
They are not mutated.
they have not done. We have been continuously telling. They have, my lord, they say that they will comply with the order.
Your lordship, one writ appeal was filed, and RP also is pending in this matter. There's a revision petition that is pending. This 2 weeks time may be granted.
Review petition.
Review petition. Review is.
In fact, my lord, your lordships are aware, my lord, review the jurisdiction is very limited unless there is any error apparent. They don't approach the Supreme Court. In fact, the Honorable Supreme Court has said, review, my lord, you cannot arrogate the power to yourself to grant stay of your own thing, my lord. It's very clear. My lord, the paragraph 2, my lord. So and so senior counsel appearing on behalf of respondent submitted that the review petition preferred by the respondent is pending before this court and therefore no further order can be passed in the present proceedings. Reliance is placed on the decision of this court in modern so and so, so and so. Next paragraph. We have gone through the aforesaid decision and the subsequent order passed by this court on 12/10/2022 in review petition so and so. The pendency of an appeal and or a writ petition along with stay cannot be equated with pendency of the review petition. There's a final decision by this court in an appeal. Merely because the stay application is pending in review petition cannot be a ground to grant stay by the respondent on its own and not to comply. My lord, January the order has been passed. When required, the government moves fast, my lord. Within a day, petitions are filed. They don't even approach the Honorable Supreme Court challenging the order passed by this Honorable Court.
I'll verify this matter, my lords. I think review is pending. Your lordship may have it next week. my
Again,
lords.
the AG is saying the review is pending, my lord, after the government advocate.
No, in the
My lord,
review,
review will not come in the way of compliance.
in the review, my lord, they've asked us to comply with that pending review. They've asked us to comply with that order. I just want to check up whether they have complied. So therefore, in fact,
I'm
they have
not aware if the review was
No,
listed also.
Not the review, there was there's an order, they're ordered to give possession to them, I think in the review or in this matter.
No,
itself.
my lord, the AG has not been properly briefed in this matter, my lord. That is in another contempt, my lord. That is in regard to
So
one more direction
I'll seek
where they were
instructions.
not, they were directed not to disturb our possession. They started to disturb, my lord. They went to the extent of, my lord, blocking the car of the advocate, my lord. The car was lifted. My lord, that the coordinate bench of this honorable court, my lord, were said that don't disturb their possession. So that has nothing to do. That is not in the review. That is in another contempt which was filed. This is with regard to mutation entry.
What is the number of?
The review petition number, my lords, is 105 of 2024.
105.
Of 2024, my lords. It is filed in writ appeal number 1115 of 2022. My lord, this is a government land, my lords, where the land has been given to the
Is filed in which matter?
writ appeal number 1115
First.
of 2022.
So this is review of 24.
Please, my lords. And this, after filing the review, we tried to mention the matter, my lords. Matter has not been listed yet, my lords.
But review cannot be a ground.
No, insofar,
There is
that's why,
no-
insofar contempt, I'll make in submission, my lords. If there's anything, your lordship may have the both along with the same next week, my lords.
Along with?
The review petition, my lord, because.
Lord, that may not,
Or
my lord,
whichever,
because
my
the
lord.
Honorable Supreme Court very clearly says review petition is not like a writ appeal or a writ
I
petition.
understand, but I'm not on technicalities.
You may take your instructions.
I'll take my instructions,
You may find out the status of review.
please,
But irrespective of the status,
Yes,
if there is no stay,
please.
then you have to comply.
yes, ma'am.
That's what I'll make my instructions, I'll take.
29.
Please, my lord.
Please.
No, except 29th, any other day, my lords. 28th or 30th, my lords.
28.
Please.
28th.
So we are not passing any order.
Not,
But if you don't come out with a satisfactory stand, we'll pass some order.
well,
Which will be the order?
well, one other thing, well, can I request the review petition also, because independent of that, my lord, yeah, I'm not independent of that, I understood what's coming from your lordship, my lord.
Normally, we are passing the orders where the appeal is filed. That unless you obtain order in.
Absolutely,
within
that's a
particular-
legal position.
You comply with.
Please, my lord.
We'll pass same order here.
No, well, we'll, I
Unless you
think,
make a statement.
well, I just have to seek instruction. Your lordship may have it 20th if.
And and that even that order may not be justified in view of this.
Well,
Yes,
not-
the Honorable Supreme Court is very clear, my lord, that
More than clear.
I'm not aware of that order copy, what may then. Not in this case.
no, the Honorable Supreme Court.
No,
they are in
that's
the High
okay.
Court.
We don't need, if there's no stay, my lord, we are bound to comply, my lord, Supreme Court.
It's something more than.
If he reads it, my lord, he'll.
It virtually says that review is no ground not to comply.
Yes,
No, that's correct, my lord. Absolutely, my lord. In fact, the matter is not listed, no notice also has been issued. The question of it's as good as not being there, my lord.
At the request of Learned Advocate General, assisted by Learned Additional Government Advocate Jafar Shah, stand out to 28th
28.
in order to
Your lordship may mention in order to show
Comply.
compliance. I mean,
20.
Oblige.
Number 36.
For the petitioner, appellant, my lord, your lordship may kindly have it on Tuesday, my lord, because senior counsel is engaged, my lord, and senior counsel Ashok Karnali appeared in matter. But he is not keeping well, my lord. Tuesday, my lord, we will be able to, my lord. Kindly grant, my lord, short accommodation. Tuesday, my lord, your lordship may have it at 2:30, my lord, specifically.
my lord, if he's seeking on health ground, my lords, I don't want to. The only aspect is, my lords, the difference between that matter and this matter is, my lords, here, the language is subject to the pleasure of the state government. And the appointment orders is still further orders. So therefore, subject to the pleasure of the government and the appointment order still further orders, it has been withdrawn. So therefore, nothing much remains. That's the only submission which I have, my lord. You can have it on Tuesday.
Lordship may have it on Tuesday. my
No,
lord.
no,
Aspect, we go to this core merit. only.
core merit, just the interpretation of this, that's all.
Your lordship may have it on Thursday, my lord, Tuesday, my lord, because the interpretation, not only interpretation, my lord, the manner in which this order is passed by a,
But in the order dated 24 for Mr. Advocate General, we have recorded that the term is over. Nominations were done at the pleasure of the government and the provision in this regard is clear. Asha, that is what we recorded.
Page 73,
Permitted by so and so, whether doctrine of pleasure would apply.
page 73, para 21, my lords. Page 73, para 21.
your lordship may have it on Tuesday, my lord, on that day, my lord. We'll argue the matter.
73, period 21.
Page 21, petitioner and WP are nominated members initially for a period of 3 years or until further orders, whichever would be earlier. The until further orders is removed. The removal of the until further does not mean that is nominated for a period of 3 years, which would be inflexible. The nomination is a nomination. Nomination cannot be equated to an appointment. Any statutorily recognized tenure to a nominee would derive a right to such nominee, not a term fixed in the order of nomination, which would always be at the pleasure of the state. No doubt nomination cannot be whimsical or arbitrary without according any reason. So,
Depends, sir, that even if it doctrine of pleasure is to be applied,
please.
then you can't arbitrarily remove.
So therefore, what your lordships will see is, my lords,
Line of the judgments now.
in fact, the line of judgments are there in identical thing.
But today you,
There's an interim order in favor of my learned friend.
find out whether the term is over or not, so that is simple.
My lord, it is still there, my lord. For 1 year, term is there, my lord. For one more year, term is there.
2020.
No, term of the body.
what your lordships are saying.
He is appointed, nominated to what? Chairman of the member of.
The chairman of the Central Relief Committee, my lords. Of the Central Relief Committee under the Beggars Act, my lords. Under section 4, that is page 104, my lords. Page 104.
104.
At 102, my lords. 102. Page. Page 102 is Karnataka Prohibition of Beggary Act 1975. Page 104 is the Central Relief Committee. 4 subclause 1, the government may by notification constitute a Central Relief Committee, hereinafter refers to as committee. Subclause 4, subclause 3, 4 2D, my lords. 4 non-official members nominated by the government. 4 2D, my lords. 4 non-official members nominated by the government. The government may appoint one of the members of the committee as this chairman and appoint a secretary who may or may not be the member of the committee. Now, subject to the pleasure of the state government, this is important, clause 3, my lords. Subject to the pleasure of the state government, the term of office of the non-official members shall be for a period of 3 years. So therefore, my lords, the nominated member, that is clause 2D, non-official members, is for a period of 3 years, subject to the pleasure, my lords. How do you? So therefore, my lords, it being subject to the pleasure of the state government. As your lordship said, my lords, it's unlike other statutes which your lordship saw, including in Rajiv Gandhi University and this word language subject to the pleasure is not there, my lords. And your lordships kindly see page 117, my lords, 117. 117. This is appointment letter in exercise of power under section 4 of so and so, so and so, so and so. Hereby appointed member of the Central Relief Committee and President with immediate effect and until further orders. So therefore, my lords, it's still further orders. So now that has been withdrawn, my lords. Even though the tenure is for 3 years, it is still further orders.
The lordship may have it on Tuesday because, my lord, the main crux of our argument will be, my lord, Annexure A, which is the a note put up by the chief minister. My lord, it says to terminate all the appointments made in the previous government. That is the word used, previous government. My lord, whether this is arbitrary or not, my lord, that will be the main issue, my lord. Because previous government, my lord, whether it's, my lord, government is a continuing entity. It is not, my lord, there is no, under the constitution, my lord, it is not previous government.
We will proceed. Let us proceed.
Sorry, man.
Ready to proceed.
Lord, your lordship may have it on Tuesday, my lord, because senior counsel is engaged, my lord. That's why I am seeking adjournment.
When shall we keep?
Sorry, my lord.
When shall we keep?
Tuesday afternoon, 2:30.
Tuesday.
Tuesday.
Tuesday, 2:30.
Please.
27th at 2. He is official, you're an official member? No, no.
Non-official. The 4(2)D, man. Sit in. There it is.
Interim order may be continued till then.
Interim order shall continue to operate. Please be next. Please.
This. Number 22.
Matter pertains to not affecting mutation in the name of the petitioner. It's the single judge not paragraph number 13. A specific direction is given to the respondents not to affect the path and name of the petitioner. And time bound direction is given for directing them within 2 months. But until now, nothing has been done with regard to affecting the order is of February 2024. It's the dispute they raised that they deny my grant. As the original records were summoned by this court, the original records were not verified. Subsequent to that, an order was passed. At para number 12, this honorable court holds of the order at page 21. In the present, I am permitted to read notes.
To the accused in this matter, Your Lordship.
What is to be done? Not complied with?
Not yet, and its order is of February 2024 months. And this is the second round of litigation. Earlier, it was filed. Some mandamus was issued. In spite of that,
What is the direction?
the direction is at para 13 lots. Para 12 lots is the observation, wherein the original records were verified and an observation is made. It's para 12 lots, page 21 lots of the order.
Enter the name of the petitioner in the right of.
We entered in the
record
revenue
that
records.
it is admissible within 2 months.
2 months.
It is not done.
No, the order is of February 2024.
In this matter, Your Lordship, the state is preferring an appeal, Your Lordship, because they do not have the grant records. There is a fraudulent entry in the grant records.
Lordship, may kindly, para 12 lots, the original was summoned. The original was in the safe custody of the court. The observation is by the single judge lots where he has himself verified lots. Para 12 lots.
When you file appeal?
Appeal is, the government order is going to come in a day or two. 4 weeks' time may be granted, Your Lordship. The order of,
If it is filed or decision is taken, we can take notice.
the decision is taken, Your Lordship.
Not filed.
The decision.
Here we are not going.
Your
to
Lordship,
grant.
decision is taken in the AG's office, Your Lordship, and only thing that we have to file the writ appeal. 4 weeks' time may be granted, Your Lordship, so we will file the writ appeal.
The directions in the order dated 12th February 24, Learned Single Judge inter alia requires the respondent Tahsildar and the Deputy Commissioner to enter the name of the petitioner in the right of records within stipulated time. Full stop. The directions are the direction is admittedly not complied with. Paragraph. Learned additional government advocate, Mr. Jafar Shah, however, submitted that the state is going to file appeal against the judgment and order brought under the contempt jurisdiction. Full stop. When queried about the decision taken, learned additional government advocate was at its receiving end and could not furnish any detail about the decision taken, much less the filing of the appeal itself. In the circumstances, the obligation to comply with the direction continues to operate. It's provided that unless within 4 weeks from today, the directions are not complied with, and the mutation entry is not, and the name of the petitioner if not entered, and the name of the petitioner is not entered in the record of rights. The respondent authorities shall stand exposed to agricultural form of.
Date may be fixed,
So within 4 weeks, whatever you want.
date after 4 weeks, months.
Yes, we'll keep it. Extend all to 19th September.
Much.
Number 23. Sakir Shamu, party in person.
It's a case of non-compliance of a single judge judgment, interim order.
Your party in person.
Yes, ma'am. We had, this case was posted first on in month of June, my lord. Then on 16th July, it was supposed to be, and there was no sitting, and it is postponed to today, but nothing has happened till today. And without salary, without workload and all of that. At Annexure A, page number 13, my lord. At page number 15, my lord. Direct the respondents to continue the service of the petition without salary and other emoluments during pendency of separate petition. We have prayed for that, and interim order is granted.
My lords, this is the direction, my lords, in fact, has to be implemented by the private respondent because it's a private institution. The thing is, it is the post is admitted to grant in aid. My lords, the matter with pertaining to superannuation, age of superannuation from 60 to 65 is pending before the full bench, my lords. It's been taken up, my lords. Similar, even the complainant is filed a petition before the full bench. The matter is pending, my lords, and the private respondent has filed a writ appeal, my lords, against this order. The writ appeal, in the writ appeal, my lords, the order has been deferred until the full bench considers the matter, my lords.
No stay has been granted in any of the petitions, my lord, by the division bench. Recently, 8th August, it had come up and it just got adjourned because.
What is before full bench?
Lords, the age of superannuation, my lords, the AICT has increased it from 60 to 65, my lords. The age of retirement in the state was 60, but the AICT has increased. That matter is being considered before the full bench. There were two contradictory decisions of the division bench, my lords. So therefore, the one of the division bench has referred it to the full bench, my lords.
He wants to continue for that.
Please, my lords, from 60 to 65, my lords, retirement age.
There are a number of decisions, my lord, because of which the age of superannuation has to be increased from 60 to 65. Nowhere the decision has been stayed. It is alive and it is operable. And
Which is writ petition 15024?
That is the petition which is pending before the three-judge bench,
That is the,
where
full-
the,
That is the very petition.
I have the full, the matter pending before the full benches. I have. There are about 12 matters pending before the full bench, Madam. Complainant is also filed, complainant's petition is also pending before the full bench.
I have even approached the Supreme Court, my lord, in this matter. And it has said if the management has failed to comply, you can approach the High Court. At page number 270, my lord. 269, 270. I'm a grant-in aid employee.
Today you are in service?
Yes, my lord. Because they are not giving the workload and not paying salary also, my lord. But I go sign and I'm on records.
That's the direction here. We cannot implement it, my lords, because this is against the private respondent. They have to continue him as a professor. We only come when that post is admitted to grant in need.
No,
These
it
are the
is a
matters
grant-in aid
pending
post.
before the full bench, my lords. May I place it on record?
I'm a grant-in aid employee, my lord. There's nothing called private here with respect to my appointment.
What is? What you are showing?
Main matter,
Can I have?
pending.
This is what?
Lords, these are the matters that are pending, including the complainant's petition that is pending before the full bench, my lords, with respect to retirement at the age of 65 as against 60, my lords. Now, the complainant has completed 60. He is no more a grant-in-aid employee, my lords, as per the state law.
The court has granted, my lord. What are?
Serial number 20 is his petition, my lords.
That's not my petition.
But then you are continuing in service.
But without any workload or salary. They give me the.
Salary,
My lord,
without salary,
pardon, my lord.
without salary.
Without?
You are paid something?
No, my lord.
No
Management.
No salary is not paid.
No salary. That is the point, my lord.
Why?
Since 10 months,
Lords may
10
kindly
10
take,
months is a too long period.
1st September onwards, nothing, my lord.
Lords kindly take page
Almost 1 year.
14, my lords, of the interim order.
We are on 14 only, yes.
My lords, in view of this admitted position, the present petitioner shall also be entitled to continue as professor. Now, this is against the private respondent. Unless and until they forward, after continuing him, they should forward it to us. Then only the granting aid will come into picture.
They
my
have
lords.
done it, my lord. I have submitted papers to the learned council today. Earlier also I gave them. College and government are blaming each other or passing the buck on each other.
There is no
That's all they are
interim,
doing.
there is no directions against the state in this interim order, my lords.
There you are right.
And Supreme Court on page number 270, my lord, 269, 270, it has targeted management. It has said if it has failed to comply, if the management has failed to comply, the directions, I can approach the High Court and get the relief. At page number 269, my lord, Annexure E.
College is there, you are for college.
Lords,
You are for college.
I'm for the institution.
What is your stand?
Lords, I'm requesting for some time, my lords, I'm requesting for some time, my lords. Yeah.
Why?
Take some instructions in the matter, my lords. The council on record has some inconvenience. I request for some time to take instructions, my lords.
They have written to the government, my lord, unless the government accepts, we are ready to pay. That is what they have replied. And 2 correspondences have happened, to and fro. And that's their stand.
No, there isn't.
And my retirement benefits are also not given. It is intact. Their only apprehension is that if I lose the case, then the salary may not be reimbursed. That is all their apprehension. My retirement benefits are intact, my lord. And I have a very good case on merits that I will get through that 65. No pension, no retirement benefits, nothing at all. And it is intact with the government. Government has to pay that. And there is a court order.
Why do you want time?
Lords,
Why do you want time?
Lords, I'll take instructions on the matter, my lords. Your Lordship may have it next week, my lords. I'll take instructions from the institution, my lords.
Tuesday,
Lords,
2 months.
Wednesday.
please,
Take, otherwise you will to comply with it.
please.
Learned advocate, sir.
Lords, Varun Joshi.
Varun Joshi, restful time, stand over to 24th. 24th. 27th. 28th. Also 29th of August. Going to be posted at 2:30.
Thank you, Madam.
December 24, to KK Vasan.
Lord, the order of learned civil judge at annexure A, page 9, and operative portion is 11, wherein directed to the respondent accused number 1 herein to pay the interest at 6% per annum on the amount of so and so from 8/7/2011 and 9/6/2011 within a period of 1 month from the date of issue of the order. Then immediately thereafter, on 19/2/2024, a notice was issued to the accused number 1, and again another notice was also issued on accused number 1 on 21/24/2024, requesting or demanding him to comply with the orders passed on 21/12/2023. They have not complied with the orders. And they have been the respondent number 1, the accused number 1 is duly served and on the present date.
Notice is issued.
Notice has been ordered, notice has been served,
Who has been-
and no one is representing. Ravi Kumar, MR, Managing Director, the My Sugar Company Limited, Mandya served. And non-filing of the reply by served A1.
Nobody is appeared.
Nobody, the warrant may be issued, my lord, they will.
Notice is notice.
Notice has been served. That is also, we should call this shows. Ravi Kumar, MR, Managing Director, the My Sugar Company Limited, Mandya served.
Rule returnable one. Not rule, rule returnable one. Other,
The other was pro forma accused, respondent. That's state government.
so endorsement on the board, endorsement on the board shows that the respondents are served in this, served with the notice of this court in this contempt petition. However, none appeared for today. 24. It's for the record shows that the respondents are served on 19/7/2024, which is 1 month ago. So the respondents were again served with the directions of the court. However, they have not chosen to appear today. And the petition was taken up also in order to obviate the allegation of non-compliance of natural justice. One more opportunity deserves to be given to the respondents to appear. Therefore, this will be a fresh notice. Therefore, therefore, there will be fresh notice to the respondent, returnable on 18th September. If the appearance is not caused or the respondent does not appear on that day, the court shall be constrained to issue the bailable warrant to secure the presence of the respondents. Official act according. Official act to issue the notice as above.
May I take steps? You will take steps for
Who?
the complainant.
Office is directed to take steps.
Right.
You just serve them. So notice was served on 11/7, what is it? Compliance. Compliance review was served on 11/7, not 19/7.
Number 25. Mahesh,
For the accused 1 to 3, my lords. Week's accommodation, I'm seeking, my lords, to file the compliance, my lords. Week's accommodation, I'll file my compliance affidavit, my lords.
13th September.
Grateful, my lords.
15 September.
26 urgent, December 27. 27.
My compliance affidavit is ready.
Page 32 is the direction.
Lots,
Applied with.
lots, the posting has, the suspension has been revoked and the posting has been given to the complainant, my lords. Page 7 and 8 is the order. Paragraph of page 8.
It is complied.
That in the face of it, it appears to be complete. May I just make, to subject to what your lordships have to say, may I just make, let's, the petitioner, my lords, the complainant, my lords, is 59 years. Now, my lords, on the eve of retirement, my lords, to be transferred from Bangalore to Bagalkot, my lords, which is close to about 500 kilometers away, my lords. Even in the face of the transfer guidelines, my lords, would be inappropriate. My lords, I was working in Bangalore, Anekal, my lords. I quite similar that I initiated contempt proceedings. I took on.
It is complete.
I'm on the eve of my retirement. I'm posted elsewhere. There was another part to the directions. Of course, whether it would lie in my mouth is a different thing. That the third respondent was held to be ineligible and he shall not be continued there.
If you want to challenge, we'll give liberty.
But by the time I go back to the tribunal, then may I make this request? Would your lordships direct them to consider if they can accommodate me in a nearby area, which is
Not
very well.
any concern.
I'm in your lordships. With liberty to challenge it. With liberty to. So great.
Number 28. Chandra Tarika.
Petitioner. My lord, rejection of the application for the renewal of the mining lease, that is question. My lord, the petitioner had the mining lease from 26/7/2002. 26/7/2002, it ends in 2022. My lord, an amendment was introduced to the Mining Act by which there is a deemed extension for 50 years. My lord, Section 8A, my lord, provides for extension of lease.
Yes.
So by this Section 8, there is automatic renewal of a mining lease. You know, the petitioner filed an application, representation to the may I take your lordship?
You are ready.
Yes, I'm ready. I'm relying on my statement of objections, my lord, since I'm a little new.
Please, may I read? Yes. My lord, kindly see Section 8, capital A of the Mines and Minerals Development and Regulation Act, my lord. This period of grant of a mining lease for minerals other than coal, ignite, and atomic minerals. The provisions of this section shall apply to minerals other than those specified in Part A and Part B of the first schedule on and from the date of commencement of the Mines and Minerals Development and Regulation Amendment Act. All mining leases shall be granted for the period of 50 years. 3. All mining leases granted before the commencement of the Mines and Minerals Amendment Act 2015 shall be deemed to have been granted for a period of 50 years. Thus, my lord, when the mining lease was granted to me on 26/7/2002, which would expired in the year 2022, it automatically gets extended under 8A3 for a period of 50 years from the date of issuance of the lease. That, my lord, my representation, kindly see at annexure F, my lord. annexure F at page 50. My lord, page 150, page 150.
Page 100
150, this was for my lord, the entire mining was stopped throughout Karnataka for a period in 2012. After that, I had given a representation on 19/7/2013. Then later, my lord, a notice under section 8A, as per amended act was issued on 31/12/2018, annexure G. Page 159. They call upon me to deposit a certain amount. And later at annexure J, my application at page 166, my application for extension came to be rejected. On 10/6/2020. Thereafter, there was a writ petition, and Matt was now at annexure M, my revision came to be rejected, against which this writ petition is filed. Page 187 is the ordering revision. Page 187, the relevant page is page 199. Paragraph 44. Paragraph 44. Thus, it is held that the revisionist, that is myself, having encroached upon an area to the extent of 15.67 hectares beyond the area granted under the mining lease, has violated the lease condition of carrying out mining operations beyond the sanctioned lease area, thereby violating section 4(1) of the MMDR Act, as per which no person shall undertake any mining operation in any area except under and in accordance with the terms and conditions of mining lease granted under the MMDR Act and rules made thereunder. Therefore, deemed extension under section 8A(3) of the MMDR Act of the mining lease of the revision is squarely barred by the application under section 8, subsection 6 of 8A. This is one reason. Another reason is kindly come to subpara paragraph 45, my lord, the subpara. Admittedly, revisionist has not filed any application before the state government explaining as to why he has not been able to undertake mining operation for a continuous period of 2 years since 18/4/2013. Therefore, the second point enumerated has no application in the instant case. Also, there has been no premature termination of the mining lease of the revisionist on the ground of lapsing of lease in the instant case. Therefore, the contention of revisionist that he had not received any notice for lapsing of lease cannot be sustained. Next, paragraph 46 said this: from a reading of the first and third point of the conclusion given by the apex court in the aforementioned case, it is observed that in a case wherein lessee has failed to undertake mining operations, kindly note this, my lord, undertake mining operations for a continuous period of 2 years, but no order declaring the lease as lapsed is passed by the state government, the lease of the lessee shall continue to subsist till the date of expiry of the lease as stated in the lease document. But where a lease has suffered a lapse, then it is disentitled to any benefit of the amended MMDR Act by application of subsection 9 of section 8A of the amended MMDR Act. Thus, in the instant case as well, since the lease of the revisionist has not been declared as lapsed by the state government, the same shall subsist. My lord, at one breath, it says that it subsists till 25/7/2022. That is till the date of expiry of the lease as per the lease document. However, since the lease of the revisionist has definitely suffered a lapse, kindly, here is a volte-face, lapse on account of non-conducting of mining operations for the last 9 years, that is from 18/4/2013 till date, it is not entitled to the benefit of the deemed extension. My lord, this one goes contrary to the other is my respectful submission for this reason. My lord, there is no lapsing of the lease. The lapsing of the lease is under Rule 28(1), my lord. Kindly see for a minute, Rule 28(1). One speaks of lapsing of leases. Subject.
1/7.
May I read, my lord? Subject to the conditions of this rule, where mining operations are not commenced within a period of 2 years from the date of execution of the lease, or is discontinued for a continuous period of 2 years after commencement of such operations, the state government shall by an order declare the mining lease as lapsed and communicate the declaration to the lessee. My lord, if it is not commenced within a period of 2 years from the date of execution, that is not the case here. What they say is, or is discontinued for a continuous period of 2 years after commencement of such operations, the state government shall by an order declare the mining lease as lapsed. My lord, state government has not declared the mining lease as lapsed. If it were to declare, it should be communicated to the lessee and communicate the declaration to the lessee. Then, where a lessee is unable to commence, that I don't come under sub-rule 2. If it is under Rule 1, that should have been a communication, and first an order, and order should have been communicated. There is no such order of lapsing in respect of the mining lease of the petitioner. Therefore, my lord, from 2012, this mines never worked in. There was complete cessation of all the mines in Karnataka, and there is no state government order of lapsing. And there is no order, there is no communication. Therefore, it's my submission that under Rule 8 capital A of the Act, petitioner is entitled for the renewal of the lease, which is up to 50 years from the date of lease. The rejection is without properly considering the application and without properly looking into section 8A of the Act. And the kindly see 8A 3 and 6, my lord. Three is, I have read it, all mining leases granted before the commencement of the Mines and Mineral Regulation Amendment Act 2015 shall be deemed to have been granted for a period of 50 years. Subsection 6 is, notwithstanding anything contained in subsection 2, 3 and subsection 4, the period of lease granted before the date of commencement of the Mines and Mineral Regulation Amendment Act 2015 where mineral is used for other than captive purpose shall be extended and deemed to have been extended up to a period ending on 31st March 2020 with effect from the date of expiry of the period of renewal last made or till the completion of the renewal period, if any, or a period of 50 years from the date of grant of such lease, whichever is later, subject to the condition that all the terms and conditions of the lease have been complied with. My lord, there is no complaint that I have not complied with any of the conditions of the lease. That is not the objection. I have complied with all the conditions, and as on this, the 2020, 22, because the lease would expire on 26/7/2022. The lease, since lease was subsisting, the benefit of section 8A 3 and 6 is available to the petitioner. That is not considered by the authority in this revision. Therefore, my lord, I am before this honorable court, and this petition, the extension of lease may be ordered. The authority at one breath says, yes, there is no lapsing. And again, it restricts it to only till 2022. There is no reasoning for this. And there is the other side has filed a statement of objection. In this, there is they have placed on record a judgment of the Supreme Court, which says, my lord, if your lordship were to please to see the statement of objection, which is an enclosure to the statement of objection at page 113, my lord. Page 113, that is the citation in 2016, 11 SCC. Paragraph 37.4. May I read, my lord? A leaseholder who has moved an application for first renewal of the original mining lease at least 12 months before the original lease was due to expire, and such application has not been rejected, will be considered to be a valid leaseholder having a subsisting right to carry on mining operations till the expiry of 2 years, that is up to 2000, as is apparent from a conjoint reading of the unamended and amended Rule 24A of the Mineral Concession Rules. Such leaseholder would have the benefit of subsection 5 and 6 of section 8 capital A of the amended Act. Next, paragraph 37.7. Based on the interpretation placed by us on section 4A4 of the, my lord, page.
Yes.
My lord, renewal is different from deemed extension.
My lord, 37.7. Based on the interpretation placed by us on section 4 A4 of the MMDR Act and Rule 28 of the Mineral Concession Rules, we can draw the following conclusion. Firstly, unless an order is passed by the state government declaring that a mining lease has lapsed, the mining lease would be deemed to be subsisting up to the date of expiry of the lease period provided by the lease document. Secondly, in situations where an application has been filed by the leaseholder when he is not in a position to or for actually not carrying on mining operations for a continuous period of 2 years, the lease period will not be deemed to have lapsed till an order is passed by the state government on such an application. Where no order has been passed, the lease shall be deemed to have been extended beyond the original lease period for further period. Here, the government has not passed an order. There is no communication. Therefore, Section 80A, subsection 3 is attracted. It gets automatically extended for a period of 50 years from the first date of lease.
What is your say, basically?
My lord, my say is that, my lord, considering that they had, my lord, leased beyond the lease period, they were called upon to pay, my lord, 14 crores, 85 lakhs as per the rehabilitation and reclamation plan, which they have not done. That is one of the violations of the terms of the lease. My lord, and my other contention is, my lord, they have not operated the lease for a period of 2 years.
That is because of the Supreme Court judgment that is on record. I have placed.
My lord, and section
Yes, sorry. Yes, ma'am. Yes.
Your Honor,
One submission, my lord.
Your Honor, cause list serial number 54. With reference to the orders issued by this honorable court, Annexure B attached with the writ appeal, the honorable court has already recognized the cause of action with full documented evidence. With reference to those orders, I request that the interim relief orders be granted today and the writ appeal be adjourned for an October date. And I would return and present the status of the receipt of the consent letter and the status of filing of the original suit in this honorable court, Your Honor. Now, if the honorable court requests that I present the legal summary of the writ appeal, I would need about 30 minutes of time.
My lord, serial number, next matter, my lord. Next, my lord,
Maybe tomorrow, you know, tomorrow I would like to be presented tomorrow.
my lord, next matter, my lord, serial number.
Tomorrow morning, I would like to get 30 minutes of time to give the legal summary of the day after tomorrow.
My lord, my next matter, my lord, serial number.
It is only matter is coming up before
9.
is only for compliance.
9.
The violation of the sanction plan. It has been going on from 2023. There is a clear direction by this honorable court. An appeal was filed before the learned commissioner also approved. There is an 100% violation. It has been held that there has been contempt, please.
Your Honor,
kindly.
Your Honor,
Next.
Kindly.
Your Honor, 9
Serial number.
is late. Right, go ahead.
My lord,
Kindly,
Lord, Your Honor.
serial number 55, your lordships.
Court officer? Court of stay. ಎಲ್ಲದಕ್ಕೂ ಡೇಟ್ ಹೋಗುತ್ತೆ ಸರ್, ಎಲ್ಲದಕ್ಕೂ ಡೇಟ್. ಆಮೇಲೆ ಮಾಡ್ತೀವಿ, ಕಂಪ್ಯೂಟರ್ ಅಪ್ಡೇಟ್. ಹೌದು ಸರ್, ಎಲ್ಲರೂ ಶಾರ್ಟ್ ಡೇಟ್.
What officer?
46. ಆಯ್ತು ಸರ್.
What officer? Serial number 29.
29, 40.
Hello, ma'am. Ma'am, full busy. What
ಬರ್ಕೊಂಡಿದ್ದೀನಿ ಸರ್, ಡೇಟ್ ಬರುತ್ತೆ ಸರ್, ಎಲ್ಲದಕ್ಕೂ ಡೇಟ್ ಬರುತ್ತೆ.
Short. 29. 29, next matter.
ಯಾವ ಡೇಟ್ ಬೇಡ ಅನ್ನೋದಕ್ಕೆ ಆ ಥರ ಬರಲ್ಲ, ಡೇಟ್ ಕೊಡ್ತೀವಿ ಸರ್, ಡೇಟ್ ಕೊಡ್ತೀವಿ ಪ್ಲೀಸ್.
ನನ್ನ ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಮಂಗಳವಾರ ಹಾಕ್ಬೋದಾ? ವಾಟ್ ಆಫೀಸರ್ ಮಂಗಳವಾರ 29 ಇದು 9ನೇ ಸರ್ತಿ.
ಡೇಟ್ ಇಲ್ಲ ಸರ್, ಶಾರ್ಟ್ ಡೇಟ್ ಅಂದ್ರೆ ಶಾರ್ಟ್ ಡೇಟ್ ಯಾವುದು
ಎಕ್ಸ್ಟೆಂಡ್ ಆಗುತ್ತೆ ತಾನೆ?
ಪರ್ಟಿಕ್ಯುಲರ್ ಡೇಟ್ ಇಲ್ಲ, ಶಾರ್ಟ್ ಡೇಟ್ ಯಾವ್ದಾಗುತ್ತೆ?
9th ಟೈಮ್ ಇದು ರೀಚ್. ಹಾ ಮಂಗಳವಾರ ಹಾಕ್ಲಿ, ಮಂಗಳವಾರದ ಬಗ್ಗೆ.
ಸರ್ ಮಂಗಳವಾರ ಅಂತ ನಾನು ಹೇಳಿಕಲ್ಲ, ಸೋಮವಾರ ಬಂದ್ರು ಬರ್ಬೋದು.
ಸೋಮವಾರ ಬರಲ್ಲ, ರಜೆ ಇದೆ, ನೀವು ಬರ್ಬೇಕು, ನಾ ಬರಲ್ಲ.
ಈ ಸೋಮವಾರ ಅಲ್ಲ ನಾನು ಹೇಳ್ತಾ
ಅದು ನಾಗಪ್ರಸನ್ನಿಗೆ ಅದನ್ನ ಹೇಳ.
ಆಸೆ ಇದ್ದೀರಿ.
ತುಂಬಾ ಹುಷಾರಾಗಿದ್ದೀರಾ.
Court officer, serial number 45. Court officer. Court officer, serial number 45, date ಬೇಕಾಗಿತ್ತು. Court officer. Court officer.
ಹೇಗಿದ್ದೀರಿ ಸರ್?
Court officer. Court officer, serial number 45. Court officer, serial number 45, please. I need a date.
Court officer? Court officer? Court officer? Court officer?